Good morning, everybody, and welcome to the Arizona State Board of Pharmacy meeting. Today is February 11th, 2026. The time is 8:30, and I'll call the meeting to order. Dr. Gandhi, if you can do roll call and conflicts of interest, please.
Certainly, Madam Chair. And Madam Chair, before I take roll call, just a reminder for the board members as well as the speakers at the podium there is to speak closely in the mic. It transfers perfectly over YouTube, but seems like the back of the room has a difficult time hearing us. So throughout the meeting, I may remind each of you as you relax a little bit in your chairs to kind of speak up closer to the mic. And with that, I'll take roll call, Madam Chair. Mr. Thorwald.
Present.
Ms. Browning.
Present.
Ms. Davis.
Present. Conflicts have been submitted in writing.
Thank you. Ms. Walmsley.
Present conflicts have been submitted in writing.
Ms. Spark.
Present conflicts have been submitted. I do have a disclosure. Would it be appropriate to mention that now? So disclosure on 24C, Andrea Daniels is someone that I know from working with in the past and will not influence or interfere with my ability to participate.
We may ask you to restate that when
Sure.
that agenda item is called. Mr. Hogan.
Here.
Mr. Al-Nassif.
Here, mine has been submitted in writing.
Thank you. Mr. Anderson.
Present, no conflicts.
And Madam Chair, Mr. Braswell has resigned, so there is a public member seat available.
Thank you, Dr. Gandhi, and if he's watching, thank you, Mr. Braswell, for your service to the state and to the board. It's been a pleasure working with him. Couple points of order before we jump into the agenda. Ms. Galvin, I see that we have somebody new at the table. I would like for you to introduce our new team member here.
Thank you very much. I appreciate that. And yes, we do have a new member, Allison Franklin. She is with the Attorney General's office, and she will be working alongside me, a co-counsel for the Board of Pharmacy. She is a recent law school graduate, passed the bar a few months ago. So we're happy to have her. And she's was with the AG's office prior to passing the bar, working as a law clerk, and she's doing a great job and has been helping us with a lot of the assignments.
Terrific.
Thank you.
Welcome, Allison.
Welcome.
Fantastic. And I'm sure Ms. Galvin will be happy to have some relief. It's hard to do two jobs. Couple of other points of order. We do offer CE for today. Make sure that you sign in the back of the room if you're interested in getting CE for the meeting. You'll need to sign in both the morning and the afternoon if you want to get credit for the entire day. With that, let's jump into the agenda. Do I have a motion to approve the meeting minutes from the last meeting?
Move to approve the minutes from the last meeting.
Second.
A motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Next, we'll move to complaint review. There was nothing that was indicated in the complaint review committee for full board review. Is there anything anybody would like to pull for further discussion for the group?
Madam Chair, I'd like to talk about tab 4A, which is complaint 25-0486.
Anything else?
I'd just like to pull 4W 25-0464.
For W?
Yeah,
Okay.
4W.
All right, let's jump into 4A. 4A is the complainant stated that the pharmacy dispensed the wrong medication to her 2-year-old son. Mr. Anderson, would you like to discuss why you want to pull it?
Sure. Thanks, Madam Chair. In this case, the pharmacist dispensed and sold the wrong medication after verifying the patient using the date of birth only. That same pharmacist also documented that they provided counseling, yet the discrepancy between the prescribed medication loratadine and the dispensed medication ondansetron was not identified during that counseling session. The complaint review committee recommended non-disciplinary continuing education and brought up good points in their discussion, but I just wanted to clarify one detail. As I reviewed the evidence, I do see two major areas that represent departures from generally accepted standards of care. The use of only one patient identifier at pickup and counseling that really did not appear to have the robustness needed to detect the error and function as a final safety check. To me, it really signals that the counseling lacked substance or any meaningful quality. And my question really was to the complaint review committee. I didn't hear much discussion around the counseling piece, and I was curious if you considered that in your evaluation for the non-disciplinary CE.
I just like to comment on this. I mean, in this situation, we don't know what's happened at the time. I don't think even the pharmacist or technician will recall or remember exactly what's happened. When with the standard pickup process, pharmacy staff will ask for name, date of birth, right, to select the right patient. So honestly, I cannot determine what's happened at that point that led to this error. Yeah. I'm sorry. So, but I like to ask our compliance officer. She's more aware of the system at that company.
Good morning, Nancy Chang, compliance officer that did the investigation for this case. In this particular incident, the response from the PIC was that the pharmacist did not follow the second verification of the patient identification. Basically went in and just got the date of birth and did not ask for the name, and was just happened to select the wrong patient at the time when both of the patients had the same birthday. And counseling I verified that, and counseling was done. And sorry, I didn't include a copy of the documentation, but verification was done, but on the wrong medication. And the patient apparently didn't know until they went home.
How did she bypass the name? Like, she asked for date of birth, right?
That information is not clear.
Did it come from her or from her PIC?
From the response is
I read-
from the pharmacist.
Yeah.
So, Mr. Nassif, it's just that there's a gap there. They require two identifiers. This pharmacist who's working the register only asked for the date of birth. There happens to be two patients with that date of birth with medications. One apparently was in the sort of working queue because it was, I can't recall the specifics, but then one was ready for pickup, and the one that was ready for pickup was the wrong patient. So the pharmacist neglected to ask the name. They just did the one identifier. In combination with that, they said that they counseled this patient or the patient's mother or father or caregiver, because this is a pediatric patient. And I don't understand how that counseling session was very meaningful when they dispensed the wrong drug. Because you would think, I mean, loratadine and ondansetron, huge difference. So at least, I mean, there should have been some sort of quality encounter there. And that's the reason why I wanted to bring this up, is like, to me, this is too many gaps to just issue non-disciplinary CE. Looking at the decision tree that we've, again, agreed to use in our decision-making process, I see this at-risk conduct, potentially even reckless, by skipping the required two identifiers.
I understand your perspective, but I also think to myself, we don't know, to your point, the quality of counseling, right? There's some responsibility on the part of the caregiver as well. And you would think that the caregiver would have said, hold on a second, at least the counseling was done, the counseling was documented. It failed in this particular case. I would feel more concerned if the counseling wasn't done at all. But we don't know what the conversation looked like, and there's no way to know what that looked like.
But it may have just been a checking of a box that it was done. and it may not have occurred. We don't know. It's documented that it's done, but clearly it didn't include all the elements that should be occurring during a counseling session. So that's why I wanted to bring this case for discussion.
Thoughts from other board members?
I don't remember us discussing the second identifier in that. I think that's an important piece. I'm glad you brought it up. That changes my perspective on the our decision at that point.
I still feel like it's a medication error, and I can see how it happened given the fact that they had the same date of birth. Is my personal opinion, but willing to hear from other board members what their thoughts are on it.
The the store policy is that usually they will ask for the name and the identification, and the birthday, and the pharmacist just didn't follow the policy.
Yeah, that's that's the policy. I just cannot imagine the pharmacist would just ask for date of birth and pick up random bag just without asking a name. And that's what I'm trying to
Correct.
establish what's happened.
Which is what the respondent pharmacist said that they did. They just used the birthday as the single identifier versus they keyed in a birthday into the system, went and got it in the will call and brought it to the register, provided the counseling. That's kind of how the narrative is reading to me. And sold the wrong prescription to the wrong patient.
I mean, I agree that we really don't know the quality of the counsel. There's maybe questions around that. I also noted the identifier piece, not having a second identifier. And I guess my question on that would be, even asking date of birth, with a similar date of birth, the year was not the same. So that's the other thing I think that sticks out to me as concerning. But I don't know that we really know the quality of the counsel. So it's, clearly an error. There were multiple ways to prevent it. So that's, yeah, just my thoughts.
I'd be willing to, if there's no further discussion, Madam Chair, I'd be willing to consider or propose an alternate motion. I would propose consent agreement for disciplinary CE and 3 hours of continuing education for medication error prevention to be signed within 30 days, CE completed within 90 days. And that would be a disciplinary CE versus just non-disciplinary.
Is there a second for that motion?
I'll second.
Any discussion? Dr. Gandhi, roll call.
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis,
Nay.
Ms. Walmsley,
Nay.
Ms. Spark,
Nay.
Mr. Hogan,
Aye.
Mr. Al-Nassif,
aye.
Mr. Anderson.
Aye.
Ayes have it, 5-3, Madam Chair.
Thank you, Dr. Gandhi. Let's go to item 4W.
Thank you. It's just really, I just like to bring up this item, which is
Oh, I'm
agree-
recused from this one.
Can you hear me?
I'm recused from this one. Let me go.
Okay. So my attention here not to change. I agree with the dismissal, but I just like to ask our compliance officer about more details about what's happened there, if you can provide us.
I'd be happy to. Good morning, board members. My name is Chirag Patel, Compliance Officer, and I was the one investigating this case, 25-0464. I'd like to point your attention to page 1606. And page 1606 is the actual hard copy that was sent electronically by the doctor. The prescription was for Adderall 20 milligrams with the indication that substitution is allowed. That means that the pharmacist can substitute to any manufacturer that's AB rated or Orange Book equivalent. But below the comment of substitution allowed, the prescriber placed a comment saying, please fill Teva only. Now, this is a prescriber comment indicating requesting a preference for the Teva brand. It also turns out that the patient had requested the Teva brand specifically also. So if we're looking at the rule, Rule 402 for the pharmacist has a duty to ensure that he or she checks the prescription order data entry and making sure that it's for the correct patient, nor did the pharmacist honor the patient's request to fill with the Teva brand and filled it with a different brand. Now, the prescription got to the point of sale where the patient inspected what was filled by the pharmacy and noticed that it was filled with an incorrect generic brand. Incorrect meaning not of the complainant's choice or the prescriber's preference. And so the complainant addressed this with the pharmacy. The pharmacy acknowledged that, yes, this is not what the patient or the prescriber requested, and proceeded to change it to the one brand that the complainant and the prescriber wanted. So that's where we're at right now. Is it an error? If we're going by the rules, the pharmacist has not made an error. If we're going by the instructions of what the prescriber indicated or the complainant requested, then an error is made. So that's up to the board members to decide whether we have a violation of pharmacy rule or law or not. This case was initially sent for dismissal. The complainant requested that the full board review it.
Thank you. And that's exactly why I brought it up, because he asked for full board to review it. From my perspective, I agree with dismiss the permit holder because it has nothing to do with permit holder here. Now, I don't see personally a violation following the rules. My concern is pharmacist has not followed up with the patient, with the provider, just to question why this specific brand, right? I mean, I know I'm aware of like there is back order problem with this, with a lot of those kind of medications, and it's been still issue with supply chain, but I don't that will raise up to a violation level from my perspective. But I just like, especially the AW, like the dispense as written, to my knowledge is applied from brand to generic for medical reasons. I don't know if specific can be to specific brand, generic name. Are you aware of any of this? I have not seen any data or reference to this.
So in regards to that, a patient or a prescriber can freely request any brand of generic they prefer. That's a preference of the complainant or patient / the prescriber. They don't have to have a specific reason on why they want that particular generic brand, but they can request that if they want.
Yeah.
I mean, I agree that I don't see that there's a violation, and I agree with the dismissal on the permit holder. The thing, like this complaint that we were reviewing was specifically on the permit holder. I know we've had questions around the
Exactly, which is I
pharmacist.
agree, yeah.
So, I mean, was there a complaint on the pharmacist previously and it's been adjudicated already?
So to address your question, usually when we send a complaint for dismissal, we only list the respondent being the permit holder. Unless we find violations or possible violations, then we include each pharmacist or technician or licensee as a respondent. In this case, because this was going to be sent for dismissal because I could not find any possible violations, I will not mention any respondents at that moment.
Okay.
Except for the permit holder.
Yeah, I mean, I'm not trying to change or make any new motion, but I just wanted to talk about this publicly. And I believe because patients, public, and pharmacists deserve to understand what they can do, what they cannot do. I believe, like in those cases, the best action or best practice is to reach out to providers or patients just for more information. And if that have been done, we won't be here. You know what I mean? Just to understand why exactly it is allergy reason, if there is any other reasons. There is many reasons, right? I understand they don't need to have a reason, but my knowledge about dispense as written is always tied to a medical reason, because specifically to brand to generic, because there is not 100% bioequivalent brand to generic. So some physicians or prescriber like to give brand only just for the outcome. Now, if it comes to a specific generic, is to me, I mean, really, I don't have any data says like you can give direction. I want this generic, but some pharmacy they don't have access to this generic, and this is the control medication cannot be transferred, cannot be. There is more is more complicated, right? So I don't see the permit holder whatsoever is so like involved with this. So I agree with dismissal 100%. But I just want to send a message that for pharmacy staff in this situation, because this second time happened with that patient at the same pharmacy, just a minimum courtesy, just reach out to patients, let them know, and reach out to doctors, let them ask them, you know what I mean? So we'll de-escalate kind of those situations. But for me, I'm not gonna change my my vote to because I agree with and I uphold the dismissal for the permit holder.
I move we dismiss 250464.
Second.
Any further discussion? Do we have to do anything like that, Ms. Galvin, since that's what the complaint committee already recommended?
You would accept their recommendation to uphold the dismissal.
I move we accept the complaint committee's recommendation to uphold the dismissal.
I amend my second.
Any further discussion? All in favor, please say aye.
Aye.
Aye. Any opposed? Motion carries. Thank you, Mr. Patel.
Okay, so we've taken care of the two that we pulled. Let's look at the rest of the consent agenda here. Give me 1 second as I get my computer restarted. Do I have a motion for the rest of the items in the consent agenda, items 4 through 10?
I move we accept the consent agenda as amended.
Do I have a second?
Second.
Jean, is that okay?
Yes.
Okay. You look like you wanted to say something. Dr. Gandhi, if you want to do roll call.
Thank you, Madam Chair. Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
I noting recusals.
Ms. Park,
I noting recusals.
Mr. Hogan,
Aye.
Mr. Al Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Oops, turn on my mic. Thank you, Dr. Gandhi. Let's go to item tab 11, complaints requiring board review. Item 11A is complaint number 25-0140, Kathy Jo Stone. We also have with this one, Ms. Stone's renewal application as well. Good morning, Ms. Sullivan. If you guys would like to introduce yourself for the record.
Good morning, members of the board. Courtney Sullivan representing Miss Kathy Stone, who is present and to my right.
Good morning.
Ms. Brown, if you'd like to give us a summary of what's before us today, please.
Certainly. Good.
It's going to be a fun day.
Jenica Brown, Executive Assistant to the Deputy Director. Kathy Stone was issued an Arizona pharmacist license by full exam on July 24th, 2002. Her license is currently open and expires on February 13th, 2026. Her application for renewal is on the agenda for the board's consideration. On or about March 12th, 2025, the board office received an anonymous complaint alleging that Ms. Stone was arrested in Nevada for child abuse and that she was abusing controlled substance medications and working while impaired. Staff sent Ms. Stone a notice of complaint and requested a response to the allegations. On March 20th, 2025, the board office received a notice of representation from Ms. Stone's attorney, along with a request for an extension to respond to the complaint, which was granted. On April 25th, 2025, a response was received and indicated that Ms. Stone believed the complaint was submitted by someone she dated briefly. It was further alleged that the complainant has a significant felony history. Ms. Stone acknowledged her failure to notify the board of her arrest and indicated that there were negotiations ongoing that would result in the dismissal of the criminal matter in Nevada. Ms. Stone clarified that she was in possession of her own lawfully prescribed medications when she was arrested and that she has never been impaired while working as a pharmacist. On April 30th, 2025, board staff issued a subpoena for records related to Ms. Stone's arrest in Nevada. A response to the subpoena was received on May 20th, 2025, followed by supplemental information received on May 21st. The documentation contained a substantial amount of information, including a police report narrative of Ms. Stone's arrest in December of 2024 in Nevada, in which officers were dispatched for a report of a domestic disturbance involving a small child who was allegedly gagged with a rag or some sort of cloth and found in a closet. Officers conducted interviews with Ms. Stone, the children involved, and the reporting party, and ultimately arrested Ms. Stone. Upon search of her belongings, officers discovered a small bag that contained a large amount of mixed pills. Ms. Stone was charged with 2 counts of possession of dangerous drugs without a prescription and 1 count of child abuse or neglect. Staff obtained Ms. Stone's prescription monitoring program report and observed that the medication described in the police report appeared consistent with the medications that were dispensed to her. On December 15th, 2025, board staff received notification that the criminal matter in Nevada was dismissed in full. This matter is before the board for discussion, consideration, and possible action regarding Ms. Stone's failure to report charges to the board within 10 days, in addition to her application for renewal of her license.
Thank you, Ms. Brown. Ms. Sullivan or Ms. Stone, would you like to say something?
Yes, we would. Thank you. Good morning. Today represents the culmination of the worst 15 months of my client's life. As Ms. Brown indicated, my client was in an abusive relationship, and that relationship escalated to the point where her abuser reported actions that he committed against the children and attributed them to my client. Nevada rightfully investigated the matter fully, as did the Department of Children's Services, and the children were returned to her custody in full, and the charges were dismissed in full. Despite all of that, the complainant did submit his complaint to the board, and my client recognizes that she failed to notify the board in a timely manner. Frankly, she was unaware of the reporting requirements for the board, and she regrets it. She was focused on her own well-being and for getting her children back into her custody. She is now before you asking that the board renew her permit or to practice and impose the $250 fine for the failure to notify.
Thank you, Ms. Sullivan. Ms. Stone, is there anything else you'd like to add?
I will be honest that this has been very emotional for her, and I don't know that she would be able to get through a statement.
That's perfectly fine. I just want to make sure that we give her the opportunity if she wanted to say something. You're welcome.
I'm sorry.
No, it's okay. Board members, discussion?
Just I need to make sure. So the medication or drug that got with her is prescription, right? And was prescribed to her.
Correct.
And the criminal charge been fully dismissed by the court in Nevada.
Correct. The prosecutor took an extensive period of time to interview all of the witnesses and present the evidence and review the evidence that her defense attorney provided to them. And they determined that there was no reasonable likelihood of
Yeah.
conviction and dismissed in full.
Thank you. Yeah, I mean, from my perspective, we are facing like just failed to report. It's been dismissed by court and it's her medications. Me personally, that's how I look at it. I don't know if anyone has any comments. I have motion to make. Okay, I would move to she's pending renewal, right? To accept renewing her license with the $250 fine for failing to report charges within 10 days.
Second.
I have a motion and a second. Any discussion? Ms. Galvin?
Is that a non-disciplinary civil?
It is a non-disciplinary. Yeah.
I modify my second.
Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you, Ms. Stone.
Thank you.
Thank you, Ms. Sullivan. All right, that takes us to item 11B.
I am recused.
Thank you, Stephanie. Complaint 25-0660, Yasmin Mercedes Selesky. And I apologize if I said that wrong. Is she online? Can you tell if she's online?
I don't see her, Madam Chair.
Do we want to continue with it or do we want to come back to it?
I don't think she's been responsive to the board staff,
True.
so I don't know if she's going to show up anyway. So I don't.
Okay, let's move on. Ms. Brown, why don't you give us a summary, please?
Jenica Brown, Executive Assistant to the Deputy Director. Yasmin Sielski was issued a pharmacy technician trainee registration on July 12, 2024. It expires on July 31st, 2027. Her registration status is open. A complaint was opened against Ms. Sielski's registration upon notification that she was terminated from employment at Smith's Pharmacy on or about October 24th, 2025 for theft of front store items. Ms. Sielski was sent a notice of complaint with a request for a response to the allegations, and a subpoena was issued to the pharmacy for documentation related to her termination. The pharmacy responded to the subpoena on December 1st, 2025, and provided interview notes and a handwritten statement signed by Ms. Sielski, which contained an admission that she took various items, including but not limited to diapers, baby wipes, sodas, water, dog food, and various food products multiple times a week over the course of several months without paying for them. She was subsequently terminated from employment. The interview notes further indicate that law enforcement authorities were notified and charges were pressed against Ms. Sielski. However, staff has been unable to locate any charges related to this matter. Ms. Sielski responded to the complaint on December 3rd, 2025. In her response, she stated that she screwed up and was just trying to provide for her family and take care of her husband's family. She further indicated that she wishes to continue a career in pharmacy. Her complete response is included in the board's files for review and consideration. This matter is before the board for discussion, consideration, and possible action regarding the facts of the complaint and the underlying conduct in this matter.
Thank you, Ms. Brown. Board members, questions or discussion?
So she has not communicated with this staff. Mm.
She has. It's taken quite a few follow-ups. I understand she does have some stuff going on in her personal life with a new baby.
Okay.
So that could contribute to some of the lack of response.
Considering this is a complaint, could we bring her in for a conference?
Yeah, we could.
I'll make a motion for a conference.
A second.
A motion and a second. Any discussion? All those in favor?
Aye.
Any opposed?
Madam Chair, if I may, if she's not responsive for a conference, do you guys want to move it to a hearing as an option as well?
Ms. Galvin, is that appropriate?
That would be one of your options, or you could offer her a consent agreement. I can't recall what we have done in the past with individuals who have admitted to a theft of front store items.
Probation, I think typically with some sort of like reporting back from their employer.
That would be another option. Participation in a conference is voluntary, so moving it to hearing because she's not responsive to a conference is not appropriate.
Yeah, typically we've done a consent for probation with quarterly reports from the employer. Is what we've done in the past for similar items.
I would be in favor of that approach.
Somebody would want to rescind the prior motion?
So we need to rescind the prior motion and start over with the move to hearing if she's non-responsive. I'll rescind my prior motion.
I rescind my prior second.
And then I'll make a motion for conference if she's not responsive, move to place her license on probation for a period of 1 year, with quarterly reporting from her employer.
Is that right? And then I second.
Do we really need to do a conference or could we just do a consent agreement for probation? I mean, what are we going to learn? And that is going to end up in a different place.
You could issue a subpoena for her attendance at the conference to see if that helps.
Yeah, I guess she's already admitted to the activity. The nature of the items that she took makes me want to hear from her.
And I agree, but it's still theft. And we've had other situations where people stole food because they didn't have money. I sounds like she was in a bad financial situation, but that doesn't negate her actions, in my opinion.
So for quarterly report from her employer, what if she's not employed? I mean,
Right, because she was terminated from Smith.
yeah,
And she's only got a trainee registration. It's gonna be very difficult to find an employer willing
correct,
to hire a trainee on probation.
correct.
And be willing to make quarterly reports.
Correct.
I-
Because the purpose of probation just to monitor licensee how they act during work. So if she's not employed, that will defeat the purpose of probation because in a year she will be out of this probation and come back to practice, right? I'm just like,
Well, her
thinking.
her registration expires in July 31st, 2027. So it's a little over a year for this trainee registration.
We have had consent agreements where we've required them to be employed, and if they are not employed, to come back to the board. I'm not sure those were successful, but it is an option.
I love that.
Thanks, Jennifer.
Okay, I'll rescind my motion.
Somebody want to take a stab at a different one?
So there is no need for conference. We can move directly to probation for 1 year, right? And you said we previously put someone on probation and they have to find a job, or
You could offer her a consent agreement, yes, and we could probably mimic the language that was in the previous consent agreement for the employment piece.
And
Okay.
the probation would not start until she was employed in the pharmacy
Oh, I
area.
like that. Yeah.
And then if she doesn't obtain employment, say within, 6 months of this action, then she would be required to return to the board.
Yeah, I like that. I'm making my motion if you can.
Madam Chair, may I
Yes.
add?
Please.
There's other options. So the initial proposal by Mr. Al Nassif and potentially consider voluntary surrender. And if nothing is signed, then move it to hearing.
I was going to say the same thing. Is that your motion?
That's my motion.
Do I have a second?
Second.
Dr. Gandhi.
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis,
I,
Ms. Walmsley,
Aye.
Ms. Spark. Oh, sorry. Apologize. Fell asleep a little bit there. Mr. Hogan,
Aye.
Mr. Al Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Let's move on to item 11D. This is complaint number 25-0367. Prescription was filled with incorrect medication. Good morning, Ms. Fuentes. If you would like to give us a summary of this. Actually, we have some folks joining us, looks like. You guys could please introduce yourselves for the record.
Darren Liu, pharmacy manager of Safeway 1874.
Please unmute your microphone, please.
Joseph Heyman, district pharmacy manager for 1874.
Dan Ricardo, pharmacy tech, Vale 2809.
Thank you. Ms. Fuentes, if you could give us a summary, please.
Ms. Fuentes, your microphone just came on.
I did get more additional information in regards to Safeway's fill activity. And so essentially what happened was a patient received a prescription bottle containing flecainide and folic acid mixed together. The patient noticed that the tablets looked different and confirmed the error was using, the patient confirmed the error using an online pill identifier. An investigation revealed that both drugs made by the same manufacturer were stored close together on the medication shelves. The technician mistakenly selected a bottle of folic acid, but failed to scan the bottles during filling. During verification, the pharmacist inspected the top of the occurrence discouraged area were labeled. Procedure for review.
Thank you, Ms. Fuentes. Do one of you want to say anything before we proceed with questions or discussion? No? Okay. Board members?
So I remember I was the board member that requested this pulled from the complaint review committee from December because of the fact that what I read was that the barcode scanning was bypassed by you, Mr. Ricondo, and Ms. Fuentes confirmed the company's policy that each bottle of medication needed to be scanned, and there seemed to be a bypass. So we really wanted to learn, how did that happen, and could you share with us how this medication scanning process works?
Well, in times when I would bypass it is if I would scan the said barcode into computer, and for whatever reason, if it would, when registered properly, I would I would look down the bottle, enter the barcode, and go from there.
So what are some reasons that the barcode wouldn't scan properly?
Honestly, even though I make sure I don't cover a portion of it or part of it, I make sure that it's fully visible. But then even though when I do make sure it is fully visible and not blocked off by any means, in my store sometimes it won't register properly, and so when that kit comes up, I just I look is enter it manually and go from there.
Mr. Liu, what's the expectation as are you the PIC at this location? So what is the expectation of your staff when a barcode cannot scan?
I'm sorry, I couldn't
What
hear
is
him.
the expectation of your staff when they're filling medications when a barcode does not scan as Mr. Recondo described? What is your expectation of your employees?
I expect them to always scan the barcodes for each and every bottle that's used. It helps to prevent errors though, and of course helps to ensure that we're getting the right product out.
So what do you think happened in this scenario?
I believe that Dane unfortunately did not scan the correct bottle, or didn't scan the bottle at all that was utilized. The folic acid I'm referring to.
How are return to stocks handled in your system? Do those scan?
Sorry, repeat the question.
How do return to stock medications, or how are they handled for filling?
At my pharmacy though, we basically, when we return the prescription to stock, we not only do basically put the return to stock label on it, I have my staff also put the label on it slightly above though, so we can always see what the previous product was inside the bottle. This is also primarily to help prevent situations where the wrong return to stock label is on the wrong bottle.
But those scan as well?
Yes, they do scan. They scan as if they were normal bottles.
Are there circumstances when the scan would not work? Like, for example, one of the things I can think about, because I'm in community practices, what happened if like a package was damaged or something like that? Are there circumstances when it's just impossible to scan a product? And how are those handled in your pharmacy?
There actually are some areas where bottles we do not scan. It's worth noting that we always try to scan, if we can, the QR codes, because the QR codes will give us the lot number and expiration date. But not all QR codes do scan. And some products, though, just in general, don't scan. Most notably, a lot of the over-counter products, such as, say, freestyle test strips, for example, or cetirizine. In those moments, though, we do basically have to kind of put the NDC in manually.
Barcode scanning is not a legal requirement, though, in this state.
That is true.
It is best practice, of course, but it's not a legal requirement for pharmacists or pharmacy technicians filling prescriptions.
100%.
But filling a prescription accurately is a legal requirement, and barcode scanning supports that process so that we protect patients from getting the wrong medication. So it's a tool that thankfully pharmacies are embracing, healthcare is embracing to improve patient safety. So although there's no legal requirement to use barcode scanning technology, if it's bypassed and a patient gets the wrong medication, they didn't fill the prescription accurately and accountability can be assessed.
Yeah, and that's why the pharmacist, verification pharmacists look at the image, look at the bottle, look at the vials. So as much as I support technology, but still technology, there's a gap. There is some time that pharmacists should use their clinical judgment. They should look at the product. I really struggle with always blame the system or blame technology. We don't want to get to the point that why do we need licensed pharmacists in the pharmacy or licensed technician? Yet we have some independent pharmacy that still use old software. When they look at the DUR, they just glance it and then look into it. They don't have flag. They don't have those privilege of scanning. And that's why I really cannot tell Primator, hey, that your technology is not good enough, because there is no good enough technology. You know what I mean? And we need licensed people to assist and make sure we give them the right medication.
I think I agree with where you're going, and I understand your perspective too, Mr. Anderson, but I think in this particular case, we don't know what happened. Was the barcode damaged on this particular package? There's no way to know what that looked like several months later. I see it as a dispensing error, just like any other dispensing error. And I don't want to disincentivize the use of technology by holding people accountable for the fact that no technology is going to be 100%, right? There's going to be damaged packages. There's going to be barcodes that for whatever reason don't scan. Like it's never going to be 100%. It's not practical.
I would just like to ask a question. It's not related to this case, just from your experience. If the bottle is 100 count and you need to dispense 120, so you have two bottles, right? Do you scan both of them or you scan one of them?
Practice is to scan all bottles that are used for the filling. So yes.
Yeah. So some company, the system allow them to scan every single bottle they use. Other software, they only allow them to scan one bottle. So to my point, you cannot always blame the system or policy, or I mean, at the end of the day, like, we have pharmacists, we have technicians. To me, it's unfortunate medical dispensing error, and that's what I look at it like any other medication error. And that's what we move to do whatever we decided.
Correct. My concern on this was not on the permit holder or the system. My concern was with Mr. Ricondo and his bypassing of that policy, that safeguard, that guardrail that his employer had placed to prevent this from happening. Mr. Liu was, what I see is, unfortunately, because of the quantity, did not see the erroneous ones underneath the bulk of the correct medication. So I agreed with the Complaint Review Committee's assessment that is non-disciplinary CE. I do believe that's human error, but I think that by Mr. Ricondo bypassing those safeguards, knowingly bypassing those safeguards, didn't escalate when the barcode wasn't accurate, and his boss is here testifying that it's the expectation that all barcodes are scanned, and his employee didn't do it. And a patient potentially this is a near-miss event, a near-miss sentinel event with these medications. And I think we always have to put the patient first and consider what could have happened here. And I think Mr. Ricondo needs some remedial CE in terms of disciplinary CE, and not just non-disciplinary CE, so that he never does this again. That if there are guardrails and safeguards in place to prevent wrong drug dispensing, that he takes those extra steps. I don't think, or as I had mentioned, I think at the last meeting at NABP, there was recent evidence showing that continuing education issued by boards not within a disciplinary package doesn't improve recidivism. So I think we really need to look at the evidence, and the evidence is saying that when you, again, with these decision tree tools, these new tools that are being provided by NABP, that we embrace them and we use them appropriately. And I think that this is at risk / reckless conduct, and it's beyond non-disciplinary CE. So my recommendation in December was to uphold the complaint committee's non-disciplinary CE for the pharmacist, to dismiss the permit, and to issue disciplinary CE to the technician because of these bypassed behaviors and inconsistent conduct with the expectations of his company and his manager.
I also agree with your comments in terms of the outcome, my reading of the outcome of the decision tree that would conclude at-risk conduct by Mr. Ricondo, and I would agree with discipline relative to the CE.
I disagree.
Mr. Ricondo, do you recall exactly what's happened at that time?
From what I recall, when I went to go grab the bottles from the shelf, from what my memory serves me, is that the right one was in front and the wrong was in back. And so when I grabbed them, I thought they were the same medications, and then I failed to scan both of them. Apparently I scanned one of them correctly and then the other one I didn't scan afterwards.
So you scan one bottle correctly, the other one you did not scan, correct?
Which is what he said in his response, which is inconsistent with his company's policies and the expectations, and which lands us in this at-risk behavior. There was, he acknowledged, he's reflecting right now that there was no defect with that barcode.
I don't know how you could remember that.
He's pretty reflective of this right now.
Mr. Recondo, did you complete CE already?
Yes.
What CE did you complete and what did you learn from it?
Like the actual title from it or from,
In general, what was the CE about and what did you learn?
it was about patient safety and about medication errors in pharmacy.
What did you learn from that, any comments on that?
To always be diligent and always, make sure I know what I'm doing is the correct thing and make sure what I'm doing what is not the wrong thing to harm the patient and to put other people in bad spots.
I included the CEs in the packet.
Ms. Fuentes, did you have anything else you wanted to add? I noticed you had your microphone on earlier.
No, Mr. Anderson.
Okay.
After what I said. Yeah.
So I just want to note to the board is Mr. Recondo had the opportunity to share with us that he's never going to bypass not scanning a barcode, and that did not come out of his mouth. He was just given an opportunity to do that. And that's my point, that non-disciplinary CE does not necessarily prevent future problems. And I think in this case, that disciplinary CE is appropriate. It's consistent with the NABP decision tree that this board agreed to adopt. And my motion would be for disciplinary CE for Mr. Recondo, dismiss against the permit, and uphold the Complaint Review Committee's non-disciplinary CE for Mr. Liu, and that would be my motion.
Yeah. I have one comment here. I don't think there is any error. Most of the error are caused because not following policy. I mean, just give me one error that took place because just pure human error. I mean, it could be, oh, pharmacists did not follow the policy because they didn't look at the image of the medication. Technician did not follow those policies made by employer or by permit holder to protect public, their clients, their patients, and themselves, right? At the end of the day, unfortunately, in our field, medical field, pharmacy, where there is error happens, and we try to minimize it, to stop it. And that's our obligation to our people. But can you imagine, and which is, I agree with everything you said, but could you imagine, like, if we're gonna look at this, we follow the employer policy, not our rules or our thoughts, you know what I mean? Just we following, because if they don't have this policy, he will be fine, right? He's not gonna be here. And this is my concern. So it's their responsibility to follow their own policy. I'm not gonna apply their policy to us. You know what I mean? Like,
And I agree with you. We're disincentivizing the use of technology that we know is safer.
yeah. And otherwise, like in 2 or 3 years from now, I will find a lot of licensee in our state has a discipline action.
I'm just not following that logic. Our duty is to prevent medication errors
Correct.
and protect the public.
100%.
And our duty is to dispense appropriately prescribed.
Correct.
No errors.
Correct.
So there are tools within systems like barcode scanning, which has been proven to prevent harm for patients, that permit holders have adopted. I'm not saying it has to be adopted. We don't have rules that say it has to be adopted. I think it is pretty much an industry standard, but it doesn't have to be adopted. But we need to dispense the correct product. And if we're not dispensing the correct product, a violation has occurred.
Correct. So what I'm saying, like, I agree with your concern. This is like the technician should have done better job with paying attention, and that's what we want him to do. We want all our pharmacy staff to do the same thing. I'm not whatsoever saying this is not important. It's very important. But, you know what I mean? My concern would be, oh, this error should not be happened. And then I need to analyze what's happened, not looking, I mean, I will look at their policy to make sure there's any gap in their policy. But let's say whole my point, if they don't have this policy, if their policy doesn't say you should scan every single
What I
vial.
think is missing in their policy is how to handle it if a product doesn't scan. Because at the end of the day, there are going to be circumstances where a product comes in damaged and there might be a barcode that is torn a
Correct,
little bit,
yeah.
a box that's damaged. There could be, a situation where a scanner's not functioning properly. Does that mean that they're not going to dispense products that day until the scanner can get fixed? I mean, there's going to be circumstances that occur in everyday life where a product may not scan. And I don't think it's fair to say to him, well, he didn't say that he's never not going to scan a product again, because that's probably not reality either.
Ms.
Yeah,
Walmsley, the comment about that is that disciplinary C is going to send home more of a message than non-disciplinary CE. And that's what the evidence is showing. And we should be practicing evidence-based, in our decision-making. I'm trying to do that here, and I'm bringing this up for discussion. I've made a motion for consideration.
Do I have a second?
I'll second call for the question.
Yeah.
May, Mr. Anderson, the disciplinary CE and the non-disciplinary CE, what type of CE, how many hours, and within what period of time?
Medication, patient safety or medication error prevention, for the disciplinary CE and a consent agreement signed within 30 days, CE completed within 90 days. It sounds like he's already taken the CE and accept CE that's already been completed if it meets those requirements.
It's only for technician, right? It is not
The
for.
disciplinary is only for the technician. The
Technician.
non-disciplinary for Mr. Liu is still, I think, appropriate.
I'll modify my second.
Any further discussion? Dr. Gandhi, roll call.
Mr. Thorwald,
I can see both sides of this, but I'm going to vote nay.
Ms. Browning,
Nay.
Ms. Davis,
Nay.
Ms. Walmsley,
Nay.
Ms. Spark,
Nay.
Mr. Hogan,
Aye.
Mr. Nassif.
Jim, I see comment before I mean, like, I agree with your point. Like, I'm not against the disciplinary or non-disciplinary, but just I don't want to see like blaming the system or the technology. We still need to hold people accountable, and they'll have to do their best to prevent errors. I mean, that's my whole, idea. But I agree with Ms. Sanders.
Mr. Anderson.
Aye.
Motion fails.
Do I have an alternative motion?
Yeah, I'll make a motion to dismiss the complaint against the respondent Safeway and against the pharmacist, and to issue 3 hours of non-disciplinary CE to the technician.
Second.
Any discussion? I've got a discussion point.
Can you do it 6 hours? It will modify your motion. Like 3 hours, like, because it felt to be disciplinary, right? But I agree with also the other opinion. Like, we need people just to learn from mistake and take it more seriously. So I don't know if you can modify to 6 hours.
I don't know how much more he'll learn. I mean, they're going to repeat the same information likely in these 6 hours, but I can modify it to 6 hours.
Amend my initial and second the new.
I would like to discuss the pharmacist. I think the pharmacist should also have CE. We typically do CE since this is something that could have potentially been caught during product review. Now, granted, I understand it was a large quantity, but I think a CE, non-disciplinary CE, would be appropriate as well.
I agree.
I can be supportive of that and amend my motion to dismiss against the pharmacy and 3 hours of non-disciplinary CE to the pharmacist and 6 hours of non-disciplinary CE to the technician.
Second.
May I clarify whether you are willing to accept the CE that they've already?
Yes.
A motion and a second. Any discussion?
I just want to point out that what you just appropriately, indicated, Ms. Walmsley, is what Mr. Liu did was a lot less in this case than the technician. And we're issuing the same level of corrective action. And that's where I wanted to make that difference between the technician's role in this medication error versus the pharmacist. And that's what the decision tree helped bring me to. So I just wanted to make that, again, abundantly clear that there's a difference between what Mr. Liu did and what Mr. Recondo did. And what we're issuing is not any different. And I think that that's unfortunate.
Dr. Gandhi, would you like to do a roll call?
I can, Madam Chair, yes. Mr. Thorwald,
Nay.
Ms. Browning, Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Spark,
Aye.
Mr. Hogan,
Nay.
Mr. Al-Nassif,
Aye.
Mr. Anderson.
Nay.
Ayes have it, Madam Chair. 5-3.
Thank you, Dr. Gandhi. How's everybody doing? Do we need a break or keep going? Anyone? All right, we press on. Huh? Go ahead. Thank you. Item 13A, Total Care Pharmacy. Good morning. If you could please both introduce yourselves.
Alex Snyder, Quarles and Brady, pharmacist attorney.
Good morning, all. Parth Babaria, pharmacy owner.
Mr. Hyber, would you like to give us a review, please?
Sure. Excuse me. Steve Hyber, Compliance Officer. Good morning, Board. This pharmacy is before the Board today requesting a deviation. To give you a little background, on December 2nd of this past year, the Board received an application for a change of ownership for Total Care Pharmacy. After completion of a satisfactory opening inspection, back in 12/21 of 22, the permit was opened and issued to the pharmacy. A routine inspection was also performed at this pharmacy twice on March the 14th of 23 and December 1st of 23. A change of ownership inspection was received on January 26th of 26, and the inspection was performed by myself on that day. And on an opening inspection, we do a little bit more than just a regular inspection. We bring the tape measure along and we measure distances to the bathroom. We lift up the ceiling tiles if they have a drop ceiling like we have here, and we look up to make sure the perimeter of the pharmacy is secure. So if anything was missed on the earlier inspection, opening inspection, we'll catch it during a change of ownership inspection or even a remodel inspection for that matter. And that's basically what happened on that inspection that I performed on January 26th. I'm sorry, the inspection that I performed. The requirement of a bathroom is currently 100 feet, lineal feet from the pharmacy. And so the firm is here today. They were essentially operating since that first inspection. Back in 25, they were operating with the bathrooms at approximately 180 feet. So they're here today to ask for that to continue with a deviation.
Mr. Hyber, do you have any concerns?
None at all.
Mr. Snyder, would you guys like to add anything?
No, I think Mr. Hyber did an adequate job.
Board members' questions or discussion?
No, we've been approving this recently. So I feel very comfortable. I move to approve the request, deviation
Second.
request.
And I think the application for the renewal.
Yeah, and approve the application for renewal.
Modify second.
I have a motion and a second. All those in favor?
Aye.
Any opposed? Motion carries. Thank you for being present. That takes us to 16A, American Health Services Sales Corporation.
Hello, this is Gerald Lynn Snodgrass. With me today, I also have Brandon Cochran, our operations manager and designated rep, as well as Tony Moore, our president of distribution and vet, as well as Ashley Hine with our compliance and regulatory.
Mr. Snodgrass, what is your role with the company?
I am Chief Executive Officer of the parent company of American Health Services Corporation, DBA MedVet International.
Thank you. Mr. Wagner, would you like to give us a summary of the application, please?
I'd be happy to. Good morning, board members. This was a review of an application for a non-resident wholesale permit due to a change of ownership. Notification of the change of ownership was received by the board on March 4th, 2025. However, and the change of ownership occurred on February 27th, 2025. A new application was not received until September 5th of 2025, which would be in violation of R4-23-601, Section F, requiring a new application be filed at least 14 days prior to the change of ownership.
Thank you, Mr. Wagner. Mr. Snodgrass, would you like to say anything to the board or anybody from your organization before we proceed with questions?
Sure. I mean, I can kind of give an overview. We brought on Lighthouse AI, formerly Pharma Solutions, to help as a third party to help us guide us through the ownership change. We brought them on February 18th. We did not have an exact close date for this particular acquisition that we acquired. There was lengthy diligence and back and forth with the seller. We acquired the business on February 27th, and then we sent formal notification to the Arizona Board of Pharmacy on March 4th. And I can go into details. This was an unusual circumstance as far as all of the challenges we found going through the process.
Thank you very much. Board members, questions, discussion?
Dr. Gandhi, do we have a standard penalty for failure to reapply within the appropriate time period?
Yes, I believe we do. It's under our non-disciplinary civil penalty grid.
So I'd like to move that we apply that standard in a non-disciplinary civil penalty for this particular applicant.
I believe it's 250, right? For that. Yeah. I second.
And approve the permit once paid.
And approve the permit once paid.
I modify my second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you for being present.
Appreciate
Item
it.
17A, hyperbaricforlife.com LLC. Good morning. If you could please introduce yourselves for the record.
Good morning, members of the board. James Taylor, attorney on behalf of Hyperbaric for Life, the applicant, and with me is Rick Ryder.
Good morning. Mr. Kalapuri, would you like to give us a summary, please?
Good morning, board members. This is Ram Kalapudi, Compliance Officer with the Arizona State Board of Pharmacy. So Hyperbaric for Life, I call it as HLF for reference, is a resident device manufacturer that makes hyperbaric chambers. In August 2025, the Arizona State Board of Pharmacy, I called the board, learned that Hyperbaric for Life HLF had been manufacturing hyperbaric chambers without a permit. The board issued cease and desist order to HLF on 9/10/2025. The HLF applied for a resident manufacturer permit on 10/22/2025. The company was formed on July 15, 2002 and registered with FDA in 2004. The FDA inspected HLF in 2010, 2011, 2018, and 2024. HLF is not ISO certified or MedSAP certified. MedSAP is Medical Device Single Audit Program. ISO is International Organization for Standardization. But hyperbaric chambers manufactured by HLF are FDA 510K cleared, ASME PVHO1 compliant. So that is safety standard for pressure vessels for human occupancy. Following the FDA inspection in April 2024, the FDA issued 13 Form 483 observations with no official action indicated or warning letters. After the HLF's response to the Form 483 observations, the FDA did not communicate further or visit HLF. The firm hired a consultant and is working on improvements. The HLF permit application before the board is due to the unpermitted manufacturing of approximately 468 hyperbaric chambers since the inception in early 2000s and 163 hyperbaric chambers since 5/18/2020 if we are going back 5 years. That's my summary. I'm ready for your questions.
Thank you, Mr. Kalapuri. Would one of you like to say anything before we proceed with questions?
We'll just take questions. Thank you.
You're welcome. Board members, discussion or questions?
This would be similar to the resident manufacturer that was unpermitted that we had the huge case about, right? Just not as many products.
Yeah, I was kind of leaning towards allowing the staff to work out a consent agreement for unpermitted activity like we have traditionally done in the past.
I'll make, my motion would be to allow the executive director to negotiate a consent agreement with a disciplinary civil penalty, and once signed and paid, issue that permit.
Second.
A motion and a second. Any discussion? Dr. Gandhi, roll call.
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Thank you for being present. Item 18A, US Pharma Limited Ltd. Is anyone present from US Pharma?
Yes. Hi. Yeah. Hi, my name is Manish. I'm the CEO and founder of US Pharma.
And what's your role?
Oh, I'm the CEO.
Thank you. Did you have
I
anybody
have-
else present with you?
I have with me
George Simons, quality specialist.
My name is Rushi Patel, in charge for operations and regulatory.
Thank you. I see Mr. Castaneda has joined us. If you could give us a brief summary of the application, please.
Yes, thank you. I'm Ben Castaneda, Compliance Officer of the Arizona State Board of Pharmacy. US Pharma currently holds a non-resident manufacturer permit, which has a status of open probation with our board. The company went through a change of ownership, which was finalized on June 5th, but we did not receive notification of that of change of ownership until, June 5th, 2025. We did not receive notification until July 22nd, 2025. Also, they disclosed on their application that in May of 2023, US Pharma entered into a consent agreement with our board for 3 years of probation. This consent agreement was based on a memorandum of understanding with the DEA back in January of 2023. During substantive review, we discovered that the officers for both entities are the same, as well as much of the corporate structure remained the same as well.
Thank you, Mr. Castaneda. Would somebody from the organization like to address the board, or should we proceed with questions?
Proceed with questions.
Okay. Board members, questions, discussion?
I guess the overarching question is you're on probation and you can't follow our rules. Can you tell us why you didn't follow our rules?
What specifically we're talking about, the submitting the chart change of ownership, or exactly what?
Correct.
So I reached out to Arizona Board of Pharmacy earlier on, prior to telling them that we were expecting a change of ownership, and I was directed to what the statute says. And at the time I submitted it, July 22nd versus June 5th? Yeah.
So what was it?
That's the date that I submitted it, that it was submitted. But that at the time, the question that I received as a follow-up was with regards to the change of ownership, where in the application it said, who is the CEO, which was the second item that they mentioned. I'm not clear about the first one with the change of ownership, which is what, a 2-week difference between June 5th.
Mr. Castaneda, it's changing ownership. Those two companies have the same owner. I know they have the same officers.
Yes, I did provide the org charts on page 2882 prior to the change of ownership, and then after the change of ownership on page 2883.
So they hold 2 permits, just to kind of clarify the situation here. They have a non-resident manufacturer permit, and this is a new application for a second non-resident manufacturer application. Correct?
That's my understanding, yes.
There was not this license, but the other one is the one that is open and on probation.
So their current permit is open and on probation, and this is an application for a change of ownership.
Okay. So what we're really dealing with here is a late chow.
That is correct. And then any possible consideration of the board based off the current officers and previous officers.
The probation and the MOU with the board was with the DEA was for 3 years, so that would have ended in January of this year, correct?
Well, the consent agreement that they signed with our board was signed back in May, and that was for 3 years probation. Sorry, May of 2023.
Ms. Galvin, would it be appropriate for us to move that consent agreement over to the new license?
Because there's no change in officers or the organizational structure, then that would be appropriate through a consent.
Hi, can I say something?
Yes, go ahead.
I guess we were not aware of this, not filing the application of change of ownership in a timely manner until, it was raised in today's meeting. What I understood from my team, the application was done on time. Can you please give us some time to look into it? What really exactly happened here? I know I was aware of Arizona consent decree, and I made my point to our team, hey, make sure you reach out to the State Board of Pharmacy at Arizona. Let's make sure we get our application filed in time. Can we come back to you on this one before you guys decide anything? I just want to understand, because my team continued to say that, no, we did file on time.
So Mr. Castaneda, it shows here that the CHOW was finalized on 6/5/2025 and that we didn't get the application until 7/22/25. So that's, to me, greater than 14 days. That's very black and white. Is that what we have?
Yes, that is correct.
But did we reach out to Arizona?
I reached out to Arizona before that
Eh,
to expect a change of ownership or what to do
So-
for a change of ownership.
Okay, so what George is trying, George is the one who filed the applications on our behalf. He's saying that, as soon as the change of ownership has happened, he reached out to the state saying that, hey, the change of ownership has happened, we need help. And let me pull those emails. We understand our application might have been submitted on 22nd, but there was a correspondence
There was correspondence
before
this
that,
day was coming.
So, Mr. Castaneda, I believe what we're facing here, it's the application. So they should apply or submit application 40 days before, not notifying the board. And that's what maybe they get a little bit confused because they might reach out to the board, but they did not apply within the 14 days.
Give me a second to find the email chain.
Yeah.
I'm looking for it right now.
So here we're talking about application, not notifying the board.
Sorry, Manish, you were on mute.
Okay.
You'd have to repeat.
While you're looking for email, I want you to understand there is not a change of ownership. Majority has not changed. Officers remain the same. Essentially, what happened is we got a private equity investment in a company.
Hannah, I see you've joined us. Would you like to add something to the discussion?
Yes, there's an email from board staff from March 4th. They told us they're writing to notify the Board of Pharmacy of a change in ownership for American Health Services Service Sales Corporation, effective February 27th, 2025. And board staff replied on the same day with the standard rules for change of ownership. So that information was provided then back in 2025.
Anna, you said a different name. You didn't say US Pharma Limited. You said something else. I just want to make sure that you're sharing the same.
Oh, pardon me, I must be mistaken then.
But the date you provided to us, that's accurate date, right? Oh, no, it's okay. So
No, apologies. This is the wrong page I'm referencing.
Ben, did you find anything?
I just found the email that I included in your packet of them attesting to the fact that the ownership change happened
page?
on page 2937 on June 5th, 2025.
So even though they send an email and communicate with the staff, there still is requirement to submit application 14 days before changing ownership. So I don't think there's a reason to see when did they send an email or if they did not send an email. Regardless, it's a proven they have not submit the application timely. And within
It's 14 days, not 30
It's 14,
days.
okay, in 14 days.
Board members, if I may, I do see a communication from the permit holder asking about what to do. What are the requirements for ownership changes? And that was back in June, but they did not submit the application until July, like you said.
So was that communication with you, Mr. Castaneda, within 14 days of 6/5?
That was with board staff on 6/9.
So they're not really ignoring, I mean, they're aware of, they're not ignoring the whole process. It just, I can see it can be confusing for like owners when to submit application, when, I mean, they're busy with dealing with this transfers and then they have to submit I mean, I see how that can happen.
Thank you.
And that's why usually we don't do it disciplinary. We just apply a fine, which is $250, non-disciplinary. Correct? So,
And they're already on probation, so the probation's just, it will continue, or is still on record until middle of this year?
Until May, I believe.
That would only be the case if we reissued a consent agreement, right, on the new permit?
That's correct. It would be an amended consent agreement applying to the new owners, which has the same officers and structure.
And then if I could just reiterate the language in for R4 23601, it says at least 14 days before there's a change of ownership as defined by R4 23110, a license or a permit issued under this board, the new licensee or permittee shall apply for a new board. So apply to the board for a new license or permit.
And they started communicating with us after the change of ownership and did not apply 14 days before.
Based on the emails and their current profile, yes.
Okay. Thoughts, anybody?
but to me, it's clear. We have $250 fine for not submit application. The question is, will we need a new consent agreement for the new permit?
I think given the fact that it's the same ownership technically and the same operators, I think that that would be prudent for us to do. If it was a completely different group of operators, I would be less inclined to think so. But because it's the same people and it was just basically a change at the money level,
Like companies.
I think it would be smart for us to reissue the consent.
And would that be through the initial duration of May of this year?
Or should we extend it because of failing?
Same people, same management, I believe so, from the way the chart I see.
I don't think we need to extend it, as my personal opinion. If not, they would have, if they wouldn't have sold, it would go away.
And the discipline would still show on
Yeah.
the new permit.
Mm-hmm.
I would agree with that.
Thoughts on a motion?
So I'd like to move we apply a non-disciplinary $250 fine for failure to apply in the proper time frame and extend the current probation to the new ownership through the term of the original probation.
Second.
Madam Chair, if I may, since we're doing a consent agreement, can we just tie the two together so we don't have two different orders going out
That's fair.
We can tie the two together
as a consent agreement?
as a consent agreement. Thank you.
Second, so modified.
Any discussion? And then once the consent agreement is signed, issue the permit. If not signed, then what do we want to do? Deny?
Yes.
Is that?
It's reasonable.
I agree with that.
I'll modify my second to reflect that as well.
Dr. Gandhi, roll call.
Thank you, Madam Chair. Mr. Thorwald.
Aye.
Ms. Browning.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Park.
Aye.
Mr. Hogan.
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you for being present. I am getting requests for a bio break, so we'll come back at 10:15. Dr. Gandhi, you're delaying us. All right, we got everybody back. Let's get started again. We will go to item 18B, Dharma Research. Is anyone present for Dharma Research? I see Mr. Hyber is present. You want to go ahead and give us a summary, please?
I'd love to, board members. Steve Hyber, Compliance Officer. Dharma Research is a Florida-based manufacturer, and they wanted to get a non-resident permit with us. They sent the application in, and we received it back in August of this past year. The applicant did disclose some prior discipline imposed by the state of Florida, and I've listed the discipline in your summary. They did pay Florida a fine of about $25,000, and that was, again, back in August of 21. So not quite 5 years ago. Because they indicated in their disclosed discipline that they had distributed drug or sold drug to unauthorized individuals, we typically will ask for them to run a report for us of what may have been distributed into Arizona. And so what I did, I went back to when Florida issued their permit to the company, which was about, I believe, March of 2013. And then I had it run all the way up to the date that I sent the communication to them, which would have been October 28th of 25. We got a response back that they had distributed 25,000 prescription drug items into Arizona. It looks like it was some, I think it was some fluoride type product, sodium fluoride gel. And I tried to get some, they didn't give me the detail like we typically get where we have dates of when it came in. I was interested in seeing that. And additional communications back were not returned. And then we kind of packaged this up and submitted it for an upcoming board meeting. And then we received a communication like in early January that they wanted to withdraw the application. They were no longer doing business with this entity in Arizona. So that's where we are today. Thank you.
Mr. Hyber, just curious, who they sold to in Arizona, was that a licensed wholesaler? Did they have a duty to, don't they have a duty to purchase from a licensed manufacturer? Was there, who purchased in Arizona? Who was the purchaser?
It's a company located on East Elwood Street. And we know who they are, and they have a permit with us.
Have we opened any sort of complaint that they're purchasing products from unlicensed manufacturers?
Not yet. No. We'll probably do that if the board wishes it. Yes.
I think we should do that.
So noted. Thank you.
Ms. Galvin is allowing them to withdraw their application. An option for us.
It is an option, but by doing that, you are setting a precedent and perhaps not addressing the fact that they operated and
without a permit.
Correct.
Excellent point.
But as they don't have a permit, and so currently under our jurisdiction, we'd have to grant the permit in order to take action, right?
You do not, because they have a pending application.
Okay.
Yeah, the option could be to deny the permit.
Based on the unpermitted activity.
That's correct.
So there's no appetite for them to want to negotiate any sort of disciplinary civil penalty with the board and move this along any further. They want to withdraw their application.
No, I don't. My interpretation is they didn't respond to any of our inquiries to provide additional detail around what was distributed. And they only basically withdrew it, saying they were no longer doing business.
I'm in favor of denying.
I would think that since they did distribute product to the state, that there should be some kind of fine against them tied in with that denial.
If they don't have a permit with us.
Is there a mechanism for that, Dr. Grundy?
Ms. Galvin, I believe there would be. And if they don't pay it, obviously we can turn it over to the Attorney General's office. We have a statute about unpermitted activity or needing a permit to operate.
I mean, it's 25,000 prescription drug items. It's a lot.
So can we deny and refer the case to Attorney General office to look into it?
Mr. Hyper?
I was just going to add, I would feel more comfortable not doing anything until we get the detail, because that's just an email with a number. I'll go
it could
into
be more than that even.
Right. I'll go into this place and I'll have them produce records, and then we'll have the detail. If we so choose to turn it over to AG, then we can do that. And then we can, do whatever we need to for the recipient.
So should we table it?
That's staff's request, it appears.
I would be concerned that they do not provide any additional information on that. I don't think we should table it. I think we should move forward with it and allow Director Gandhi to negotiate with it and have allow recourse if they don't negotiate or come back to us with any numbers.
But Mr. Thorwald, what Mr. Hyper can do is, because we do have jurisdiction over the purchaser, is we can look at their purchase records to see if they purchased more than this 25,000. So we have some additional data elements that Mr. Hyper can collect.
Because at this point, they're not being responsive anyway.
Correct.
I would like to make a motion to table it for further investigation.
Yeah, while you're sitting here debating, I'll double check to make sure that address does correspond with a currently open permit.
I would second Lori.
Is there any chances that they sold anybody else in the state?
This was their only response, was this three little bullet points.
So I have a motion to table. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Motion carries. Item 20A, AIM RX 3PL LLC. Is anyone present from AIM RX 3PL LLC? Good morning, Ms. Fuentes. If you could give us a brief review of the application.
Yes, hi, Beatrice Fuentes, Compliance Officer. AIM 3X3PL applied for a non-resident change of ownership on August 11th of 2025. During review, we learned that the Chow change of ownership occurred on June 5th, and the board was notified on July 9th. This application is in front of you today because they failed to timely notify the board of the change of ownership.
Thank you, Ms. Fuentes. Discussion or thoughts on a motion?
I'm just talking about the time. So they submit application on July 9, right?
August 11th, they submit the application, applied for the permit on August 11th.
Oh, applied on August 11.
Yes.
Okay, but okay. Sorry,
The
got it.
change of,
Got it now.
change of ownership occurred on June 5th,
Okay.
and they informed the board on July 9th.
So I move to approve the application upon paying $250 fine for not applying for changing ownership in timely manner.
Second.
Non-disciplinary?
Non-disciplinary, yeah.
Modify second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Dr. Gandhi, you and I had talked about potentially trying to do legislation earlier in the day. Do you want to do that or you want to keep going in order?
We can keep going, Madam Chair.
Okay. Item 21B, Integra Life Science Corporation. Is anyone present from Integra?
I'm Eva Tan, in-house counsel for Integra Life Sciences. I'm present online for any questions the board may have.
Ms. Tanner, are you licensed as an attorney in Arizona?
No,
Are you, Ms. Galvin, do you want to ask a question?
Her appearance would be limited to factual statements.
Okay, thank you. Mr. Castaneda, if you could give us a review of the application, please.
Yes, certainly. Ben Castaneda, Compliance Officer, Arizona State Board of Pharmacy. This is an application for the renewal of a non-resident manufacturer permit. Integra Life Science Corporation is a non-resident manufacturer of medical devices. On its 2025 renewal application, it disclosed a 2024 FDA inspection, which resulted in an FDA Form 483 letter with 7 observations. And that was issued on August 22nd, 2024. This escalated into a warning letter from the FDA based off of the company's responses to the 483 observations. I did reach out and asked for a response to the 483 and the warning letters. And at the time I wrote the summary, I had not received a response. The applicant did respond to me on January 20th, 2026. And while they did not provide the documentation I requested, they provided a summary, which stated that the entity sends updates to the FDA every 2 months and has been doing so since 2024. It has closed 16 of the 18 CAPAs that they initiated, with the 2 remaining CAPAs in verification of effectiveness. And they have plans for completion of the remaining 2 CAPAs by the end of 2026.
Thank you, Mr. Castaneda. Would someone from Integra like to make any comments before we proceed with questions for you?
no, I'm here for questions. Thank you.
Board members, questions, discussion?
I guess my question would be to Ms. Tan as to why the responses to the warning letter in 483 weren't provided.
Yes, because the responses are pretty long. We file the initial response and have submitted updated response every 2 months. So each one is very long, including hundreds of pages. It's hard to upload. And so we provide a summary to the current status of the responses. And one thing I want to emphasize is that at the time that the FDA issued a warning letter, it determined that the product recalls or product holds were not necessary. And I checked on the FDA website over the last 12 months, no complaints were filed about the products manufactured in that plant.
I would like our compliance officer to have the opportunity to review those responses.
Totally agree.
I mean, I'm not opposed to approving an application, but I absolutely think we need to give him the opportunity to review the responses and make sure that we're protecting patients.
So now it's pending renewal. That's what we hear, right? So
Yes, the permit is currently up for renewal. I believe that the expiration date has been extended till after this board meeting.
so can we approve it, and then order subpoena or?
I would recommend against approving the renewal. If their application that was submitted is timely and complete, the permit will be allowed to continue, can remain open. But there's been a request to see the full responses rather than the summary. So I would table the application, table this
know that.
matter, issue a subpoena for the full responses.
And in that case, would that be the latest response or all the responses over the past year or two?
What I'm thinking, the same date that Mr. Castaneda requested. So, do you know what time did you request? What date?
You want to know the date that I requested?
Yeah, I mean,
the
when you
date-
requested.
I'd like to see their response to the FDA 483s and any subsequent communication from the FDA regarding their responses.
I agree. to that.
Totally agree.
So how the motion would
And
look like?
that will be my motion.
So, board
Second
members,
your
can I ask just a clarifying question? So we're asking for the responses to the 43s and the warning letter, correct?
Yes.
Definitely.
So motion is to table the application, request the subpoena the additional information, and have it come back before us. I have a motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you for being present.
Thank you.
Item 21C, Daniel Holland Lindstrom.
I'm recused.
I'm present.
Good morning. If you could please introduce yourself for the record.
Are you talking to me, Daniel?
Yes.
Oh, yeah. Daniel Lindstrom. I live in St. George, Utah now, and just seeking renewal of my pharmacist license for Arizona.
Thank you. Ms. Bolts or Ms. Perez, I think. If you'd like to give us a summary of the application, please.
Of course. Bridget Perez, a licensing administrator. Daniel Holland Lindstrom was issued an Arizona pharmacist license on July 26, 2013. His license is currently open and unrestricted. He submitted a renewal application on October 1st, 2025, and disclosed disciplinary action taken against his Oregon pharmacist license in 2024. On or about April 2017, May 2018, and May 2019, Cascade Natural Health Pharmacy, where Mr. Lindstrom was the pharmacist in charge, was inspected by Oregon board staff. Each inspection noted multiple violations as outlined below the summary. On May 13th, 2024, Mr. Lindstrom entered into a consent order with the Oregon Board of Pharmacy, which suspended his license for 30 days and ordered him to pay $1,000 with $500 stayed pending compliance with the terms of the consent order. He was placed on a probation period of 3 years. The consent order also stated that he may not be employed in a managerial or supervisory position, including but not limited to PIC, pharmacy manager, pharmacy director, consultant pharmacist, or residency supervisor. Upon review of Mr. Lindstrom's Arizona pharmacist renewal application, it was noted his employment information had not been updated since September of 2021 in iGov, and displayed he was still employed as the PIC for Cascade Natural Health Pharmacy. Mr. Lindstrom's employment information was updated in October of 2025. Mr. Lindstrom's Oregon pharmacist license lapsed on June 25th of 2025. His Utah license was issued on August 4th of 2025.
Thank you, Ms. Perez. Mr. Lindstrom, would you like to say anything before we jump into questions for you?
No, I'm here for questions.
So why do you want to keep your Arizona license? You said you're living in Utah?
Yes, I live in St. George, Utah, so right here on the border. Just in case if I ever move back to Arizona, my in-laws live down there, and Colorado City has a pharmacy right here, close by.
What's the status of your Utah license?
It's unrestricted.
My concern
Active.
here is he allowed his Oregon license to lapse, which means his probation kind of went by the wayside. And I'm concerned that it might have been a way to potentially get away from the disciplinary action. I'm typically not in favor of necessarily reciprocal discipline, but in this case, I feel like we may need to potentially do some sort of probation to mirror his probation that was issued in Oregon.
That's my concern as well, and I agree with that.
I agree as well.
Does anyone have additional questions for Mr. Lindstrom or discussion on a motion?
If I may, Madam Chair, as well, just keep in mind that he also didn't update his profile until October 11th, 2025. He indicated he left Cascade Natural Health Pharmacy in May of 2024.
So are we thinking offering a consent agreement for probation to mirror the terms currently in Oregon and a payment of a civil penalty of $50 for failure to update contact information within 10 days? And if not paid or signed and paid within 30 days, move to hearing? Or does that seem appropriate, Ms. Galvin?
Perhaps you would want to move that you would grant his application upon the signing of a consent agreement for probation that mirrors Oregon and upon the payment of a $50 civil penalty for not updating his employment profile.
That would be my motion.
I'll second.
Additionally, do you want the probation to end when Oregon would have ended, or do you want it to start
Yeah, I think
anew?
I wrote in my notes, I think it looks like 5/13/27. Is that correct?
I believe so. He entered into that agreement in 2024.
Yes, that would be my motion.
I have a motion and a second. Any discussion? Dr. Gandhi?
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis? Oh. Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Thank you for being present, Mr. Lindstrom.
Yeah, thank you.
Item 21D, Desiree Boone. Is Ms. Boone present? I think there's a chance she will not be present. Ms. Brown, why don't you go ahead and give us a summary, please?
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Desiree Boone was issued a pharmacy technician license on March 13th, 2013. Her license expired on October 31st, 2024. Ms. Boone submitted an application for renewal of her license on February 12th, 2025. The application was deemed administratively complete on September 11th, 2025. Ms. Boone disclosed an arrest on her application, which occurred on or about April 3rd, 2022. Police records from her arrest indicate that Ms. Boone's breathalyzer result was 0.151% at the time a field sobriety test was performed, and blood test results later revealed the presence of THC, cocaine, and ethanol. Ms. Boone pled guilty to one count of aggravated driving or actual physical control while under the influence of intoxicating liquor or drugs, a Class 1 misdemeanor. The board considered Ms. Boone's application for renewal during the October 2025 board meeting and voted to table the application and issue an interim order for substance use evaluation. The interim order was issued on October 30th, 2025 and required Ms. Boone to undergo an evaluation within 60 days. On November 13th, 2025, Ms. Boone contacted staff and indicated that she scheduled an evaluation with a board-approved provider on December 26, 2025. On the date of the scheduled evaluation, staff received an email from the evaluator indicating that Ms. Boone did not appear for the appointment. On December 29th, 2025, staff contacted Ms. Boone to inquire if she intended to undergo the evaluation as ordered and reminded her that failure to comply with the order could result in the denial of her renewal application. Ms. Boone did not respond. Staff sent a follow-up email on January 14th, 2026. Ms. Boone responded on the same day and requested an extension. Staff asked Ms. Boone to provide a date for which she was requesting an extension. Ms. Boone did not respond. Staff sent a follow-up email on January 20th, 2026 and requested a response by January 21st. Ms. Boone responded on the same day and indicated I believe I'll have the information for you tomorrow. I'm just waiting for one more price check. Staff advised Ms. Boone that if she did not provide a date by the deadline of January 21st, 2026, the matter would return to the board. As of today, Ms. Boone has not provided a date for which she is requesting an extension. This matter is before the board for discussion, consideration, and possible action regarding Ms. Boone's application for renewal and her non-compliance with the interim order.
Thank you, Ms. Brown.
So her license is inactive now, right? Because
Correct. It expired in 2024. Mhm.
But today we have a renewal application before us
so we can deny, is that right? So there's an option to deny her request.
based on her failure to comply.
Yeah.
That is correct.
Okay.
I'll second that.
That was my motion.
Okay. I have a motion and a second. Any discussion? Dr. Gandhi, roll call.
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi.
Would the board also accept a consent agreement for the denial of her application in the alternative?
You mean a voluntary surrender?
Well, I believe you said her license had expired. Had she been notified of the complaint prior to that?
I don't believe there's a complaint open. It's a renewal application. The board voted to table it, issue an interim order, and now we're at the point where she has failed to comply with that order.
If you would agree to accept a consent agreement for the denial of the application instead of us doing a notice of denial and her having the ability to request a hearing, it might avoid that hearing. So would that be appropriate if I could also see?
So we need to modify the
No,
motion.
if I
or
just have consensus that you would
Yeah,
accept.
yeah,
the
this, I'm
consent.
totally fine with that, yeah. Yeah.
Oops, my mic is off. Everyone good with that?
Yes.
All right. Did we take a vote? Or did we stop? Okay. I couldn't remember. We'll go to item 22A next. I am recused. So Jeff, take over.
Thank you, Ms. Walmsley. This is pharmacist application for Daryl Ray Parrish. Is Mr. Parrish on the line?
Yes, Daryl Parrish here.
All right. Thank you, Mr. Parrish. And looks like we have Ms. DeLeon. Would you like to provide us a summary?
Erica De Leon, Licensing Administrator. Daryl Ray Parrish applied for pharmacist licensure via reciprocity on October 14th, 2025. The board may wish to move into executive session in order to discuss personal health information.
Thank you, Ms. DeLeon. Do we have a motion to move into executive session?
I move we go into executive session.
And that would be to review confidential health information and receive legal advice if necessary.
Correct.
I second.
Yes.
All in favor, please say aye.
Aye.
Aye. Any opposed? Motion carries. Mr. Parrish, please remain on the line and you'll be invited into a private room.
Yes, okay.
executive session. Any further discussion out here in public before we entertain a motion?
I'll make a motion to approve his license.
Second.
Any further discussion? All in favor, please say aye.
Aye.
Aye. Any opposed? Motion carries. Thank you, Mr. Parrish. Board staff will be in touch.
Very welcome. Thank you. I'll leave the rest.
All right, we'll go to item 22B, Mark Corona, pharmacy technician trainee applicant. Is Mr. Corona present?
Good morning, I am.
Hi there, if you could please introduce yourself for the record.
My name is Mark Corona.
Are you able to turn your camera on for us?
Yes, ma'am. Let me see here. There we go.
Thank you very much.
How are you guys?
Well, thank you. Ms. Castro, if you'd like to give us a summary of his application, please.
Sure. Christina Castro, licensing administrator. Mark Corona applied for a pharmacy technician trainee registration on October 4th, 2025. During the review of the application, it was found that Mr. Corona was arrested and charged with 3 counts of aggravated assault in 1999. On October 12, 1999, police officers responded to a shooting at a residence. 3 individuals were sitting outside the residence when Mark Corona arrived. He exited his vehicle and began firing a shotgun. 2 of the 3 victims were injured. When questioned by police, Mr. Corona initially denied involvement, but later admitted responsibility, stating that he had messed up. He indicated that his intention was not to harm anyone and that he acted out of frustration and stated that one of the victims has been harassing his grandmother. He admitted to consuming 8 to 9 beers and 1 shot of tequila 1 to 2 hours prior to the incident. Mr. Corona was convicted of 2 felony offenses: discharge of a firearm at a structure, a Class 2 dangerous felony, and aggravated assault, a Class 3 dangerous felony. He was sentenced to 7 years in prison for the discharge of a firearm conviction and 5 years in prison for the aggravated assault conviction, to be served consecutively. He was also sentenced to 3 years of probation in order to pay restitution. Mr. Corona has fulfilled all terms of his sentencing. He petitioned the court to restore any and all civil rights, and his motion was granted on September 11, 2011. Thank you.
Thank you. Mr. Corona, would you like to say anything to the board before we jump into questions for you?
Well, I guess it all depends on how much time you guys would want to give me.
Why don't we just proceed with questions for you? If
Okay.
that sounds okay. So that way we can keep it germane to the information here. I guess
Sure,
my first
absolutely.
question for you is, looks like this criminal activity happened back in 1999. Have you had any other legal issues since then?
No, ma'am.
And you completed all of your required penalties as a part of those charges?
This is correct.
Okay. Why are you seeking a pharmacy technician trainee application?
Well, I've been a plumber for the last, I guess almost 20 years now. And I came to the point where I thought, maybe I would like to pursue a medical career. This gave me probably the best opportunity to do so. I'm in my mid 40s and I don't know how much more time I got as far as my education goes. So I thought, well, maybe if I get my foot in the door, we'll see what other avenues this can lead to. And so when this opportunity presented itself, I decided to take it. And that's kind of where I'm at right now. I've always enjoyed serving my community. And I just thought maybe just another door that could be open to me to do so.
Thank you. Board members, any additional questions or discussion?
I guess my only question is about a fingerprint clearance card. Is that
Mhm.
required for a tech trainee?
When you were working as a plumber, Mr. Corona, excuse me, were you licensed with the Register of Contractors?
Actually, I currently am. I'm part owner of a company in Phoenix called Triplum Plumbing, and also I'm a secondary holder or primary holder for a license in Northern Arizona. So yeah, the registered contractor does actually involve itself pretty frequently on what we do and how we conduct our business. And so I was also conducted a bunch of background checks through them as well. And then I did receive my fingerprint clearance card. I was denied initially for it because of my background, but upon appeal, I was granted level 1 security clearance.
Have you had any complaints against you with the Register of Contractors?
No, ma'am.
And your fingerprint clearance card is current?
Yes, ma'am. Actually, I just received it. Oh, my memory doesn't serve me right now. Just maybe 2 months ago or so.
If I may, that's how the board was alerted to these charges, is that fingerprint clearance card application.
Considering the timing, this was a really long time ago. It's already been adjudicated, and since then he's been compliant with the law. I would make a motion to approve.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Aye.
Any opposed? Hearing none, motion carries. Best of luck to you, Mr. Corona.
Praise Jesus. Thank you guys so much.
Item 22C, Nizoni Rose Chakoa Gamble. I apologize if I said that wrong. If you could please join yourself and correct me on how to say your name, because I'm sure I butchered it.
Nijoni Gamble.
Welcome. Ms. Brown, if you could give us a summary, please.
Certainly. Najoni Gamble applied for a pharmacy technician license on May 1st, 2025. She currently holds a pharmacy technician trainee registration, which expires on December 31st, 2026. On her application, Ms. Gamble disclosed a 2022 arrest and conviction for extreme DUI. According to records provided to the board on November 1st, 2022, a Glendale Police Department officer observed Ms. Gamble reversing into a lane of traffic and almost striking a vehicle traveling in the proper direction. The officer reported Ms. Gamble smelled strongly of alcohol and asked her to exit the vehicle to perform sobriety exercises. A breathalyzer was performed with a positive result of 0.233. Following her arrest, a search of her wallet revealed a small plastic bag containing a white powdery substance, which later tested positive for cocaine. The board considered Ms. Gamble's application during the October 2025 board meeting and voted to table the application and issue an interim order for substance use evaluation. The interim order was issued on October 30th, 2025 and required Ms. Gamble to undergo an evaluation with a board-approved provider. Ms. Gamble complied with the order and underwent an evaluation on November 10th, 2025. The results of the evaluation were received on December 18th, 2025 and are included in the board's files for review and consideration. This matter is returning to the board for discussion, consideration, and possible action regarding the results of Ms. Gamble's board-ordered evaluation and her application for a pharmacy technician license.
Thank you, Ms. Brown. Ms. Gamble, would you like to say anything to the board before we proceed with questions?
No, thank you.
Okay. Looks like in her evaluation that does not recommend any treatment or monitoring. Given that and given the fact that she complied, I am comfortable with issuing her license is where I'm at right now.
Agree.
I'd like to make a motion to approve her license.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing no, motion carries. Congratulations, Ms. Gamble. Thank you for being here. Item 22D, Brock Cordell Amos, pharmacy technician applicant. Is Mr. Amos present? Someone from staff like to go ahead and provide us a summary?
Allison Okanowski, licensing administrator. Brock Cordell Amos held a pharmacy technician trainee license, which expired December 31st, 2024. On his trainee application, Mr. Amos disclosed 2 charges for assault and disorderly conduct in 2020. Mr. Amos applied for a pharmacy technician license on October 23rd, 2025, and failed to disclose these charges. On October 12th, 2020, police were called to an apartment building. Upon arrival, the officer met Mr. Amos and his partner. Mr. Amos explained a verbal argument started in his apartment, which turned physical. Both individuals admitting to touching the other in self-defense, and police stated the parties appeared to have aggressed upon each other. Mr. Amos was charged with 2 counts of assault and disorderly conduct. He pled guilty to 1 count of disorderly conduct and was placed on a domestic violence diversion program. After 9 months of successful unsupervised probation, his charge was dismissed and probation terminated on August 10th, 2021.
Thank you. Board members, questions or discussion on this one?
Ms. Okanowski, has he been communicative with staff?
He has provided all documents I have requested.
This would just be a failure to disclose. So I make a motion to approve his technician license with upon payment of a $250 civil penalty for failure to disclose charges.
Second.
A motion and a second. Any discussion?
I have a question.
Yes.
Don't we normally put something in there that if he doesn't pay, then it's not approved? Upon payment?
We don't normally.
Okay.
All those in favor? Aye.
Aye.
Any opposed? Hearing none, motion carries. Thank you.
But I'm sorry, if he doesn't pay, we open another complaint that he's not.
Item 23A, complaint number 24-0560, Howard Pulver. Is Mr. Pulver present? Good morning, Ms. Trujillo.
Good morning.
Is Mr. Pulver on?
Yes, I was going to ask that question. You made a jump there, so.
I don't see him online.
Oh, yes, I see him.
Hello, Mr. Pulver. If you could please introduce yourself.
Hi, Howard Pulver.
Good morning. Ms. Chang, if you'd like to give us a summary.
Yes. Good morning, board members. Nancy Chen, Compliance Officer. At the board's October 2024 meeting, the board considered case 240560 and voted to offer Mr. Howard Pulver an interim consent agreement for probation, examination, and continuing education. The interim order for examination and education were executed on March 14, 2025 by the board's executive director, which stated that Mr. Pulver shall complete a continuation course and successfully pass the MPJE by September 14, 2025. Mr. Pulver completed the ACPE continuing education course on May 3rd, 2025. He submitted the application for MPJE on August 27, 2025, and was approved to take the exam on September 8, 2025. However, he was unable to take the MPJE at that time. So on September 16, 2025, the board approved extending the MPJE examination date. Mr. Howard took and passed the MPJE exam on December 12, 2025. This matter is returning to the board for final adjudication as he had complied with the term and to the terms of his interim consent agreement for examination and continuing education.
Thank you, Ms. Chang. Mr. Hu, would you or Mr. Pulver like to address the board?
No, we're just happy to answer any questions you may have.
Ms. Galvin, I have a question. So procedurally, this complaint 24-0560 has never been adjudicated. So the interim consent agreement that we had him complete all these activities that he appears to have completed, does that reflect on his record anywhere as any sort of discipline or anything? Is our duty now to finally adjudicate with some sort of memorialization of that complaint?
The interim order is non-disciplinary. So that's the answer to your first question. The second question is, yes, the complaint 240560 has not been adjudicated. So you would need to address that.
Before we go into a motion, I do have one question for Mr. Pulver. Mr. Pulver, we've talked to you a number of times about both your pharmacy permit and your own conduct. What have you learned over the course of the last roughly 2 years that we've been having these conversations?
Just because when we took over from the other person that they said they have everything, doesn't mean they actually had everything, and then we need to make sure that we have everything.
And Mr. Pulver has had successful visits by Mike Blair as part of the settlement agreement that's in place for the pharmacy itself. So he's been having regular and successful inspections by Mr. Blair. I think you even got a report, just recently from him. So the pharmacy is continuing to operate in compliance, with the law, and we seem to be in a good space here.
Ms. Cheng, how was his last inspection?
So since the execution of the board order inspection, I have completed 2 inspection quarterly. It's a quarterly inspection. The last inspection was on September 10th, and that went pretty well. It shown improvement, definitely with organizations and sanitations. He did quite a bit of work in trying to organize his area, record keeping, and there was still some area of improvement that I still need to look into with record keeping and patient profile documentation. I think also in June, he transitioned to a new computer system from the old DOS system to a window-based with technology for barcode scanning. I think that will help him with some of the profile record keeping. So I'm hoping to come back and visit the next time. I was not able to do my inspection in December because the pharmacy was closed when I went there. And also due to some health and family situation that require him to close the pharmacy a little bit more frequently at the end of the year. But my hope is to be able to go back and do another inspection coming up. But in terms of for his own legal counsel, they had completed 10 inspections so far, and it seems like every time they went through, they were able to see some improvement. So I think I'm looking forward to see more of his record keeping, and also looking for inspection with his controlled substances, because that's an area of variation previously.
Thank you. I do think we need to memorialize something. I don't know that I think we need to put him on probation or any of those kinds of things. He's already done a lot, but I do think that I would like to see something disciplinary on his license is where my head is, because these were pretty serious violations. And
Agree. And the probation, if I recall correctly, we couldn't do because he's the PIC or is the only pharmacist in this community. So that's why we went with this ICA route.
yes, my thought is possibly like a decree of censure on his license is where my head is.
If I may, I want to clarify that the interim consent agreement was reported to the National Practitioners Data Bank. It is reflected just as a interim consent agreement or interim order on the website. So it's reflected with the National Practitioners Data Bank.
Ms. Walmsley, I would support your if you're thinking of a motion for a decree of censure, I think that seems appropriate and I would support it.
So moved. Do I have a second?
Second.
And this would have to be accomplished through a consent agreement at this point in the proceeding. It is disciplinary, and so it would be through a consent agreement.
So moved. That's fine.
Ms. Galvin, do we need to memorialize why I think Mr. Anderson kind of pointed out we didn't move to probation because of the geography? Should we memorialize that to create a distinction why we didn't do that versus if another matter comes up and
That could be reflected in the findings as the board did articulate that concern.
You good? Dr. Gandhi, roll call.
Mr. Thorwald?
Aye.
Ms. Browning?
Aye.
Ms. Davis?
Aye.
Ms. Wamsley?
Aye.
Ms. Spark?
Aye.
Mr. Hogan?
Aye.
Mr. Al-Nasir?
Aye.
And Mr. Anderson?
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Thank you, Mr. Pulver, for being here, and I'm glad to hear that your pharmacy continues to improve.
Thank you.
Forward to hopefully not hearing any violations come back to us. Thank you very much.
Right, me either.
Take care.
Bye.
Item 23B, complaint number 25-0538, Thomas Fong. Good morning. Could the parties please introduce themselves?
Good morning, members of the board. Courtney Sullivan, appearing on behalf of Mr. Fong, who is present and to my right.
Good morning. Thomas Fong.
Good morning, Ryan Grease, PAPA Program Director.
Thank you. Ms. Brown, if you could give us a summary.
Jenica Brown, Executive Assistant to the Deputy Director. Thomas Fong was issued an Arizona pharmacist license by Reciprocity on August 20th, 2018. His license expires on October 31st, 2027. It is currently suspended. On or about September 18th, 2025, board staff received a notification stating that Mr. Fong was under investigation for inventory discrepancies in the pharmacy. It was further noted that there were concerns for possible impairment in the workplace. On the same date, Mr. Fong contacted staff and indicated that he has been a confidential participant in the PAPA program for approximately 1 year. His communication is included in the board's files for review and consideration. Mr. Fong subsequently entered into an interim consent agreement for interim suspension of license, which was considered and approved during the October 2025 board meeting. According to documentation provided by the pharmacy, on or about September 8th, 2025, the pharmacy manager reported a possible issue of theft of pregabalin and named Mr. Fong as the possible person who may have taken the drugs. It was further stated that an employee noted unusual behavior by Mr. Fong on the afternoon of September 4th, 2025, including acting strangely, dropping things, dozing off, and mixing up patient paperwork. When asked if he was okay, Mr. Fong allegedly stated he had a migraine and just needed to go to lunch and eat something. After Mr. Fong returned from lunch, the employee went into the same break room and noticed a pill capsule on the floor under the chair Mr. Fong was sitting in. The pill was later identified as pregabalin. A count was conducted of the pregabalin and a shortage of 11 pills was identified. Mr. Fong was allegedly the last person who counted the pills and recorded the wrong count. It was further stated that the routine counts were not usually done for pregabalin, so it was unusual for Mr. Fong to have performed a count on them. The pregabalin was checked again the following day, and 3 additional pills were discovered missing. A different employee also reported that on September 8th, 2025, Mr. Fong appeared out of it. A count of carisoprodol was conducted on the same day, which revealed a 45-pill shortage that was not documented properly by Mr. Fong, who counted the pills earlier that day. It was further stated that Mr. Fong was observed handling 5 milligram and 10 milligram bottles of Zolpidem and cycle counting them, even though they are not drugs that are typically cycle counted. The employee waited for Mr. Fong to leave for the day, and she conducted another cycle count of Zolpidem, which she noted a shortage of 11 pills. On September 9th, 2025, Mr. Fong submitted to for-cause testing and was placed on administrative leave pending further investigation. The results of the drug test were negative, but did not include pregabalin, zolpidem, or carisoprodol. It was noted that a second test could be conducted to include those drugs. However, it would have been 10 days past the incident and the urinary analysis would not detect the drugs any longer. On September 17th, 2025, Mr. Fong was interviewed by Pharmacy HR to clarify the discrepancies of the 3 drugs in question. Pregabalin, missing 14 capsules, zolpidem, missing 11 tablets, and carisoprodol, missing 45 tablets. Mr. Fong did not admit to or take any responsibility for the missing drugs. A DEA Form 106 was subsequently filed for the missing pregabalin, which referenced Mr. Fong's suspicious behavior and the single pregabalin capsule that was found under his chair in the break room. On September 23, 2025, Mr. Fong voluntarily resigned from employment at the pharmacy. Mr. Fong underwent an evaluation with a board-approved provider on October 23, 2025. The results are included in the board's files for review and consideration. Also contained in the board's files are confidential records related to Mr. Fong during his period of suspension. This matter is before the board for discussion, consideration, and possible action regarding the facts of this complaint, the results of Mr. Fong's evaluation, and the suspended status of his license.
Thank you, Ms. Thank you, Ms. Brown. Ms. Sullivan, would you or Mr. Fong like to say anything?
Yes, I believe that we both have a few words we would like to say. Mr. Fong has taken this matter very seriously, along with his sobriety and his overall long-term goals. He is grateful for this board's opportunities that have been presented to him, and I'm going to let him share a few words of what he's learned and captured from this experience.
Thank you and good morning. First, I'd like to just state that I am deeply ashamed and disgusted by my behavior. Upon reflection, I don't think I had adequate understanding of the power of my disease or enough respect for it. And although this process, these last 5 months have been really tough on myself and my family, I do look back at it as overwhelmingly positive. I mean, I've been a part of PAPA as a voluntary participant for 14 months now. I went through 90 days of professional treatment, and you know, I go to multiple meetings a week, and I'm working the steps with my sponsor. And I think this is actually a very good timing, this meeting with my work on the steps, because I'm on the 9th step, which is the amends step. And so I'd like to make an amends to the board and to the rest of my profession about my behavior. And just want to let you guys know that, sobriety is the most important thing in my life. And I understand and I'm motivated that it will stay that way. And I'll maintain that for the rest of my life as well. Thank you.
I think so I think Dr. Decker's evaluation is important to note, that there are restrictions that can be placed on Mr. Fong's license to allow for the safe practice of pharmacy. We would ask that this board follow those recommendations and allow my client to return to practice.
Thank you, Mr. Fong, for sharing your story. Glad to hear that you are doing well in your recovery. Does staff have any concerns with his compliance at this point?
No concerns at this time.
Thank you. And you're supportive?
The PAPA program is supportive of him returning to work. I believe you received a letter from, or an email from his counselor, Jim Corrington. Relapse does not have to be part of someone's recovery, but it's not also surprising necessarily. And within the early recovery that Mr. Fong was in, it's not something we would like to see or want to see, but it is something that does happen. As soon as we became aware of the situation, we were able to escalate and afford him the opportunity of having the treatment that he really needs. So we are confident in his foundation that he has laid at this point, and I believe he's set up for success moving forward.
Thank you, Ryan. Thoughts?
I'm happy to make a motion. My motion would be to offer consent agreement to resolve the case. Once signed, lift the suspension and place the license on probation to include the restrictions and provisions as outlined by the evaluator for a period of at least 5 years, with all standard terms and conditions, and if not signed, move to hearing.
Second.
I have a motion and a second. Jeez, that's loud. Uh, Any further discussion? Dr. Gandhi, roll call.
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al Nassif.
Aye.
And Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Congratulations, Mr. Fong. Glad to see that you're doing well.
Thank you, everyone.
All right, that takes us to item 24A. Are they here yet, Dr. Gandhi? Or did we notice them after lunch?
Don't see them online, Madam Chair. One moment, though. No, they are online, Madam Chair. Ms. Ivy, can you unmute and
Yes. Hello, board members. This is Ivy Nguyen. I'm the pick at Assumption No Maricopa.
Thank you, Ivy. This is complaint number 25-0428. Mr. Hyper, if you could please start with a summary.
Yes, ma'am. Hello again, Steve Hyber, Compliance Officer. This was a request. This case was in front of the board back in December, and there was a request from the board to obtain some additional information, which we've put into the report here. Let's see. The first page that you're looking at, page 4351, that's a page to replace one where we had a problem with one of the links. So let's come back to that page when we're within the report. The first page that I'd like to begin with is page 4352, okay? What we obtained, we had a meeting with an outside consultant who consults this particular small hospital. It's like a little hospital that sits on a corner, very small bed count. And then the PIC. We obtained some information that was requested, and that had to do with the around some compounding that was being performed. Well, let's also not forget the underlying citation that I issued back when the original complaint was presented to the board. We have that as well, okay? But we really focused on, with the additional information, we looked at FDA information, whether any of the drugs were on shortage. Now, remember, that's a snapshot in time. So we did find one of the particular products that they were compounding did show up when I looked around late December of 25, when I was initially doing this investigation, was showing up on shortage. The rest of these compounded products, which may or may not have commercial products readily available, were not listed on the current FDA list. Okay, and if we move along to page number 4362, I kind of gave a little summary there of our call with the aforementioned PIC and the consultant pharmacist. There's also a link there. This is the link that did not convert correctly, so you can go back to that earlier page in the beginning for the actual link that works. But that's a copy of the formulary, of the current formulary of the hospital pharmacy. Then moving along is the evidence of the FDA shortage list that I mentioned. That's on page 4376. And then after we go through that, we get to the original underlying complaint, which we had a couple of violations that we had cited them. One against the permit holder and some citations that we cited against the PIC. Any questions at this time from me?
I don't have any board members.
Thank you, Mr. Hyber. I do want to thank you for the additional work and the follow-up since our December meeting. It appears from what I can see with the additional information that you've provided and that's in the book, it does support my initial concern that the pharmacies not complying with their own policies for supplying compounds in the most ready-to-use form, particularly these 5 vasoactive drips. So that was my major concern, is that they're not following their own policy on that, and that's one of the, I think, this violation you cited, AAC R423-670C1, which requires a permit holder and pharmacist in charge to prepare, implement, and comply with their own policies and procedures for compounding and dispensing. So the standouts to me, and Madam Chair, if I may, ask the PIC a question, just your crash cart policy. Your crash cart policy states that emergency medications will be provided in the most ready to administer form available. And also your medication mixing, administration, and documentation by clinicians policy states that medications are dispensed in the most ready to administer form possible to minimize opportunities for error, and that the pharmacy department is responsible for providing medications in an as ready to use form as feasibly possible. So that's what alerted me in December, is you've got these very clear policies. And I recall the language from the ED provider concerned about the delay in getting the norepinephrine drip because of the compounding with the original complainant. So that's what, prompted some of the discussion. So given those written policies, I guess, Ms. Wen, how do you reconcile your current practice of compounding these norepinephrine and other vasoactive drips when these commercially available products are available?
Yes. Thank you. For your question regarding, we do try our best to utilize the current supplier. We only have one supplier. McKesson is our current only supplier for all of our drugs. And regarding the policy, yes, we do try our best to carry all the premix and ready to use. But the scenario at the moment, when back in the time of the complaint happened in August of last year, is the norepinephrine in the smallest available dose is 4 milligram and is on our formulary. Norepinephrine drip should be 4 milligram in 250 ml T5W diluent. That specific strength and formulation is not available to be ordered and shipped. So we have to immediate compound at the moment when the provider place the order, verbal order. During codes, events, all of that emergency cases, we have to snap on the small vials of 4 milligram per 4 ml into the diluent of T5W 250.
Understood. So, but that wasn't in the response at the time, like there was any sort of attempt or there was a manufacturer shortage at the time. And Mr. Hyber presented documents to us that these are available through your wholesaler, your primary wholesaler. So I guess, how do you reconcile that you didn't state that these weren't available through your wholesaler at that time, and he's showing evidence and screenshots that your consultant provided that they are commercially available? At least that's what I'm seeing.
I beg to differ a little. I think
Okay.
their responses were to support their, they may not have told us initially, but their responses did indicate that it wasn't readily available. My responses that were in regards to where it wasn't unavailable were to the FDA. screen prints. So
So Ms. Nguyen, you're consistently saying that these commercially available premixes are not available through your primary wholesaler. Is that what you're saying is why you don't stock them?
The exact strength, the smallest strength of 4 milligram per 200 ml 50 premix is not readily available through McKesson, our only supplier. And even right now, when I look it up, it's not available.
again, when we had a conversation with them and they sent us screen prints when they were logged in to McKesson, and it wasn't showing up on the McKesson order guide. So
It was not
it
showing.
was
up.
not.
So it was not available.
Right. I suspect that these products probably come and go, because I would imagine you would want to use ready to mix.
Right.
It's faster. And I hate to say it, but I think the contribution to it being slow not only was the fact that they had to mix it, but there was a training going on during a code, I think it was Blue event, and it was a day one employee. Probably not the best time to attempt to do a training, because these people that come in that you get hired, they're not going to be familiar with all your processes.
So Ms. Nguyen, are you making attempts to try to stock these commercially available premixes, knowing that these are safety? Obviously, your policy states that this is the safest way to do this. Obviously, the workload for pharmacy staff, nursing staff, physicians is much improved when these commercially available products are utilized. Is there any sort of attempt to source outside of McKesson, or routinely look at McKesson's inventory to see whether or not you can get it, or connect with McKesson to stock it in their distribution warehouse because they are commercially available? What sort of attempts are you making to provide and comply with your own policy?
Yes, to answer your question, we do have a list of, as you can refer to our co-card policy and the components in the co-card of the medication stock in there. We do, if McKesson available and able to start to deliver to us, we do have other drugs like dopamine, dobutamine, premix, and all of the antibiotic IV intravenous injections. If is available in premix, we would always try our best to fully stock them in our hospital per policy. And it had to be compliant, approved by P&T committee to be approved on the institutional hospital formulary. And regarding norepinephrine specifically, this drug, McKesson do have a higher dose. So it's like double dose of 8 milligram per 250 ml premix, but we want to carry the smallest dose, and the 4 milligram, which is half of the dose that is available in premix on McKesson. We, on our formulary, we approve the smaller dose of 4 milligrams. So that's the reason why we don't have the 4 milligram readily in premix. That's another thing that we, even we try our best to reach out to McKesson. And I hope that answered your questions.
It does. I'm pleased to hear that attempts are being made to stock these commercially available products. That's the safest way for taking care of Arizonans, and so I'm pleased to hear that. The concern, I think a takeaway for you, Ms. Nguyen, is talk to your P&T chair and the medical staff about norepinephrine 8 milligrams and 250 or any other formulations, because these are all just rate controlled. And if you can get commercially available products, you're doing a better service for your patients. And you're complying with your own policies, just by hanging your hat on the fact that the 4 milligram per 250 ml bags weren't commercially available, I guess does alleviate any violation concern that I had in December. But the safest practice is to stock these commercially available products, and 4 milligrams and 250 of norepi is very low dose. And these 8 milligrams and 16 milligrams and 250 are pretty much industry standards. So I think you should talk to your P&T chair and your ED docs about stocking these 8 milligram and 250 doses as a minimum, because if the supply from McKesson is more readily available, you're doing a better service for your patients and you're meeting your own policy.
Madam Chair, may I ask a question? So Ms. Nguyen indicated that their sole source is McKesson. Is there, and Steve and Ms. Nguyen, maybe one of you can answer the question. Is there a restriction on partnering with only one distributor? Have you identified anything, Steve?
No, I haven't heard anything. That might be something that they would have to answer. The consultant pharmacist may have an answer to that, because that would probably play into their business side of the business with decision making, on price and things of that nature.
Ms. Nguyen, is there a restriction with your organization to partner with more than one wholesaler or distributor?
Can I have this question answered by my consultant pharmacist? Can we let Kevin in the meeting? My consultant pharmacist is Kevin.
I don't see him in the meeting right now.
Oh,
Also,
regarding restriction, to my best knowledge, we would have to reach out to consultant pharmacists and have a corporate meeting with our COO, Chief Operating Officer, and we would have to reach out and discuss more if we can have a second supplier besides McKesson. We use McKesson as our primary because that's the largest inventory and offering that we could get.
Yeah, to Dr. Gandhi's point, I mean, the product that we're referencing here is available through Baxter. So who supplies your IV fluids? Do you have a Baxter direct account that you also source?
No, we only use McKesson, given the nature that we are very small.
Just to follow up, Madam Chair. Steve, on your review, did you notice that this was a shortage on the FDA website?
There was only one, and it wasn't the one we're talking about now. Let me see if I can find the page that referenced the one shortage. There was only one that was listed on this FDA shortage list as unavailable, the dopamine, hydrochloride, and dextrose 5, 400 over 250. And that was on their list of drugs that we saw in a MAR statement that they are on their compound list. So they would mix that using the particular ingredients. So they weren't purchasing that one from what we can see. We didn't see that listed on the formulary that they provided as well.
So, Mr. Hybrid, this is a situation where something is, sorry, I'm over here. This is a situation where something isn't shown as shortage on the FDA's drug shortage list, but also isn't reasonably available from their local wholesaler.
Well, that would apply to the other ones. Yeah, this one was unavailable till it looks like January. Remember, I did this snapshot in December.
Ms. Nguyen, I'm curious, do I have confidence that you are attempting to source these products through whatever sources your company allows you to source, so that you are complying with your own policy and stocking the most readily available, commercially available compounds for your patients?
Yes, we do try our best to stock all of the commercially available, and I do appreciate your feedback that if we have to propose to P&T committee to change our formulary to the specific strains and adjust our rate to stock the one that McKesson is currently available for norepinephrine.
I think, Ms. Walmsley, we were landing on an advisory letter last time, and I was the one kind of the outlier. And after hearing more from Mr. Hyber and from Ms. Wen, I think that path is fine with me or the permit holder.
Any other discussion?
Do we need to make motion?
Yes.
So it was advisory letter, right? As I remember. So I keep this motion. I move to. It was for the permit holder and the pharmacist, right? Back then.
I can't remember the specifics.
So I would send both for both, like for the pharmacist or pharmacy in charge and the permit holder advisory letter regarding the policy of compounding medications.
I'll second.
Have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you, Ms. Wen, for being present.
Thank you.
Can we do item 25A? All right, 25A, discussion, consideration, and possible action regarding the request made by Lauren Roof to terminate her probation. Is Ms. Roof present? Welcome. If you could please introduce yourselves.
I'm Lauren Roof.
Ryan Grease, Pop-Up Program Director.
Thank you. Ms. Brown, if you could give us a summary.
Certainly, Jenica Brown, Executive Assistant to the Deputy Director. Lauren Roof was issued an Arizona pharmacist license by Score Transfer on August 15, 2017. Her license expires on October 31st, 2027. It is currently open and on probation. On August 7th, 2023, Ms. Roof notified board staff that on or about June 15th, 2023, she was charged with a DUI. Records provided by Ms. Roof indicated that she was charged with extreme DUI, back 0.15% or more, extreme DUI 0.2%, DUI alcohol, drugs, toxic vapors, or combination, and DUI with alcohol concentration of 0.08% or more. The events that led to the charges occurred on or about December 2nd, 2022. An interim order for substance use evaluation was issued to Ms. Roof on August 24th, 2023. Ms. Roof complied with the order and underwent an evaluation with a board-approved provider. Ms. Roof subsequently entered into a consent agreement for probation with monitoring, which aligned with the evaluator's recommendations. The agreement was executed on February 9th, 2024, and placed Ms. Roof's license on probation for a minimum period of 2 years. Along with standard terms, the agreement outlined the following. Ms. Roof was required to enter into a monitoring contract for the entire term of her probation and comply with each and every requirement of the contract. She was required to establish care with a physician specializing in addiction medicine or addiction psychiatry, and she was required to ensure that the physician submits quarterly reports to the board. On December 10th, 2025, Ms. Roof submitted a request to appear before the board to request termination of her probation. PAPA subsequently submitted a letter endorsing her request. Ms. Roof is in compliance with the terms of her consent agreement, and there are no concerns from staff.
Thank you, Ms. Brown. Ms. Roof, would you like to address the board?
Thank you. I acknowledge and take responsibility for the actions that led to my DUI and the subsequent probation imposed by the board. This incident represented a serious lapse in judgment that does not reflect the professional standards I hold myself to as a pharmacist, nor the responsibility entrusted to me in serving the public. I understand the gravity of my actions and the potential impact they may have on patient safety, public trust, and the integrity of the profession. I understand the importance of accountability and do deeply regret this mistake. I appreciate the board's oversight and view the probationary process as an opportunity to demonstrate growth, responsibility, and renewed commitment to myself and my profession. Since this incident, I have taken intentional and constructive steps toward recovery and personal improvement. I have remained compliant with all probationary requirements and successfully completed a mandated substance abuse monitoring and recovery program, which provided me with valuable insight into the behaviors and decisions that contributed to this event. I have implemented concrete changes to support sustained sobriety, sound decision-making, and personal accountability, including ongoing self-reflection and adherence to structured recovery practices. I am committed to maintaining these positive changes long-term and to upholding the highest ethical and professional standards moving forward. I respectfully request the board's consideration of my compliance, progress, and continued dedication to safe and ethical practices.
Thank you, Ms. Ruth, for sharing your story. I'm glad to hear that you are doing well in your sobriety journey. Mr. Grease, anything you'd like to add? We have your letter of support.
Papa is fully supportive.
Thank you. Board members, questions or discussion?
I'll make a motion to approve her request for probation termination.
Second.
A motion and a second. All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Congratulations, Ms. Rafe. Glad to see you're doing well. Do we want to take a recess for lunch? Come back at 1? We'll come back at 1. Thank you. All right, welcome back, everybody. Dr. Gandhi, do you want to do a roll call to reestablish the quorum, please?
Mr. Thorwald,
Present.
Ms. Browning,
Present.
Ms. Davis,
Present.
Ms. Walmsley,
Present.
Ms. Spark,
Present.
Mr. Hogan,
Here.
Mr. Al-Nassif. Here. Mr. Anderson.
Here.
All accounted for, Madam Chair.
Thank you, Dr. Gandhi. We will go to item 11C, Amanda McHale.
I'm recused.
Welcome back. If you guys could please introduce yourselves for the record.
Good afternoon, everyone. My name is Alex Snyder, counsel for the respondent with Quarles and Brady.
Amanda McHale, pharmacist.
Ms. Brown, if you could please give us a summary.
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Amanda McHale was issued an Arizona pharmacist license by full exam on December 6, 2022. Her license expires on December 31st, 2026. It is currently open. On or about September 26, 2025, the board office received a complaint alleging that Ms. McHale posts pictures on social media while she's at work that contain protected health information or information that is very closely related to protected health information. Staff sent Ms. McHale a notice of complaint and requested a response to the allegations. Ms. McHale responded on October 28, 2025, denying the allegations and clarified that she has, on rare occasions, posted work selfies. She further stated that if there were any pictures posted, they are appropriate. Included in her response are examples of photos that she has posted online. Staff requested additional information from the complainant to corroborate the allegations. The complainant responded with several screenshots of what appears to be Ms. McHale's Facebook and Instagram profiles. Of note, one screenshot contains what appears to be a printed patient profile with a hospital problem list. The complainant indicated that the screenshot is from two short clips posted on Ms. McHale's Facebook, where she was allegedly flipping through approximately 15 pages of the hospital problem list and commenting, "Is that all?" The patient's name is able to be identified in the screenshot, even though it appears that an attempt was made to redact the name. The complainant also provided screenshots of instances in which it appears Ms. McHale has documented scenarios related to her work on Facebook, disclosing information such as patient age, patient sex, and reasons for admission. All of the documentation provided by the complainant is included in the board's files for review and consideration. On October 29th, 2025, staff provided Ms. McHale a copy of the supplemental information from the complainant. Staff asked if she was the author of the social media posts depicted in the screenshots provided by the complainant and requested a response to the supplemental information. Ms. McHale responded to staff's additional questions and acknowledged that the accounts in the screenshots belonged to her. Further, she acknowledged that a colleague reached out to her expressing concerns regarding the clip where a patient's name could be read through an attempt to redact it. She stated that after it was brought to her attention, she deleted the clip to ensure patient confidentiality. In response to the additional allegations, she stated that she is very cautious and intentional about the information that she chooses to post on social media. She makes sure to be thoughtful about her posts, including what information is shared and what needs to be concealed to ensure confidentiality of patients. She clarified that her goal in her posts is to spread awareness as to what pharmacy entails and the various capacities in which pharmacists operate. She indicated that moving forward, she will not be participating in social media. Ms. McHale's complete response is included in the board's files for review and consideration. This matter is before the board for discussion, consideration, and possible action regarding the facts of this complaint.
Thank you, Ms. Brown. Mr. Snyder or Ms. McHale, would you like to address the board?
Yes, I'll issue a short statement followed by Mrs. McHale. So first, we just want to thank the members of the board for allowing us the opportunity to appear before you today. We just want to clarify some key points just for the board's consideration as you discuss this complaint. As our understanding that the board has found Dr. McHale that she violated HIPAA privacy standards as they are incorporated into the Arizona revised statutes, the Pharmacy Practice Act. And while these standards are pretty extensive, it's clear that the general privacy rule states that a covered entity may not use or disclose protected or individually identifiable health information. However, this protected health information can be de-identified prior to use or disclosure to satisfy the privacy rule in accordance with these federal regulations. In all the posts that we have reviewed and within the complaint, she had attempted to de-identify by removing any identifiers of individual patients. Unfortunately, it is clear that in one post, while the name was blacked out, upon careful inspection, you can still make out the name of a patient. But still, the intent was always to try to redact the patient identifiers to remove any indication or any piece within the posts that could be traced back to patient information. And the purpose and content behind such posts were always to advocate for the profession or to share her day-to-day experiences as a pharmacist practicing in the community in the way that it could be potentially beneficial to the public. But after review and contemplation and dealing with this complaint, she now realizes that the risk of sharing patient information is not worth the potential benefit that it may provide to the general public, and has since decided that she will not be using social media in this fashion anymore. To that end, she has actually deleted her social media accounts that were cited in the complaint, that being Facebook and Instagram. And she just remains committed to the practice of pharmacy, to making sure that the profession itself works to protect the health and safety and welfare of the citizens of Arizona. And now I will turn it over to Amanda to issue a small statement.
To add on what Alex is saying, I have not taken this matter lightly, and it was not my intention to disclose patient information. I have taken the steps necessary moving forward to ensure this does not happen again. This includes removing my social media, reflection on the given situation, education from my legal counsel, and reinforcing my understanding of patient confidentiality standards. My goal in my posts was to spread awareness as far of pharmacy practice and the different capacities in which we operate as pharmacists. I attempted to de-identify the related health information, but it was not enough. I have practiced extreme caution since this incident, deleting both my Facebook and my Instagram accounts. I have a duty as a pharmacist to patient confidentiality, and I am learning that my professional and personal work life do not mix, and they need to be kept separate.
At this time, we'll open up to any questions.
Thank you. Board members, questions or discussion?
I would just make a comment that when something's put on the internet, it's always there. And even when after you delete accounts, if you go back to programs like Wayback, you can pull up anything that's ever been put up on the internet. So nothing's really gone.
Mr. Snyder, you mentioned the covered entity, so the employer in this case. So what has happened with the employer and this and potential disclosure? Can you share what has been done on from the covered entity?
Is that related to any discipline or anything like that that the employer?
Correct. Have they acted? Are they aware that this occurred? And have they taken corrective action to report the disclosure, the inadvertent disclosure? What's the covered entity done?
Could you speak to that?
I work at 2 sites and I don't remember which site that happened at.
So does that mean you did not share or disclose this with your employer?
No.
She said no,
Know that
that she has not disclosed this breach of patient confidentiality to the covered entity. Ms. McHale, what does your employer state about policies on posting while at work, posting on social media?
I looked at the policies and procedures of my given hospital, and there is no specific policy about social media in the workplace.
Is there anything about photography in the workplace?
Only with consent.
I'm sorry, could you, which page? Because I need to see if there is specific, like patient's name, because I can't see any specific patient name or.
The screenshot where the patient's name was attempted to be redacted is on page 2126.
Thank you.
I would appreciate board staff's perspective regarding the pharmacist employer on this. You know, as the custodian of record for the patient records that were disclosed, what obligation does the permit holder have? And maybe this is best for legal advice in executive session. I'd like to make a motion for legal advice.
Second.
All those in favor?
Aye.
Any opposed? All right, welcome back, everybody. Additional questions for Ms. McHale?
I would just like to also take this opportunity to state that after discussing with my client, we are more than happy to alert the pharmacy of the post and work with them to work out what to do next as it relates to any next steps with regard to the potential disclosure.
And Mr. Snyder, that should have happened. That should have happened ahead of time. Very disappointed to hear you attempt to make amends, but to this board, but the patients that you improperly refilled PHI for, you didn't attempt to alert them through your employer and make that appropriate disclosure, which is disappointing.
And you've put your employer at potential risk from action by those individuals. And you didn't even tell them about it so that they could remedy it.
Ms. McHale, you look very familiar to me. Have you been here recently?
So approximately last year, before we were retained as counsel, she did appear before the board for another related event that I believe was handled. And I believe it's in the board file. It's a non-disciplinary letter of concern.
And Mr. Anderson, I believe the question was directed to the respondent.
Yes, I was here last year for a different case.
Under what circumstances were you here?
Sorry, can you clarify?
What matter were you here in front of this board for?
It was deemed medication prevention or medication error prevention.
What was the complaint that brought you here in front of this board?
Insufficient dosing of vancomycin.
So you said like you post those things for education purpose to educate public about pharmacy. So when you post a list of diagnosis code and you comment, is that all? Is this part of the education you provide to public, or it is just kind of having fun?
That was supposed to be a lighthearted attempt to show the complexity of some of the patient cases that we get and how we handle them as pharmacists. But I would say that despite that attempt to redact the name, that probably should not have been posted to begin with.
I would move that the board find violation with unprofessional conduct and proceed with disciplinary action for this pharmacist.
I would also think that the board should follow, that staff should follow up to make sure that the facilities are in fact informed of the violation.
Mr. Anderson, could you articulate, please, the potential statutory or rule violations?
For violation of HIPAA. Constitutes a violation of HIPAA privacy standards under 45 CFR Parts 140 and 164.
Thank you.
So what are you thinking? If you are moving towards disciplinary action, do you have thoughts on what you would like to do with it?
Not necessarily. Does anybody have any thoughts on? On accountability?
I mean, I think potentially some retraining around HIPAA is warranted here.
Notifying her.
Because once she determined that her actions were inappropriate, she should have notified her employer so that they could do all the necessary disclosure steps to meet their requirements with federal law. And that didn't happen either. So I think that there's an opportunity for her to learn here at a minimum.
And just to amplify that, it didn't happen until we questioned more about that.
I apologize for not notifying my employers sooner. If I would have known that I should have done that, I would have done that, and I apologize for that. And I will be notifying them as soon as this board meeting is over.
Do you do regular HIPAA training with your employer? Like most
Correct.
employers, if they're have government contracts, require HIPAA training annually.
Yes.
Okay.
So you just mentioned you work in 2 sites. That's why you don't know which side, so you didn't report. Are those 2 sites owned by the same company or?
No.
Okay. So you have 2 different jobs, right? Like 2 different.
Correct.
Okay.
And you've made posts from both companies?
I don't remember, but most likely.
So you'll report to both companies?
Yes.
So Ms. McHale, you specifically called out Facebook and Instagram. I know there are other popular platforms out there. Did you abolish those profiles for yourself too? Or are you still on social media to some extent?
Thank you for asking that question. I'm still on LinkedIn for professional networking.
Have you made any posts about patient information on LinkedIn?
No.
Do you have copies of the photos that you took on your personal cell phone?
No.
Did you delete those from your phone?
Yes.
What do you think? A letter of reprimand? A decree of censure?
Consent agreement for probation with some terms that she can't be a preceptor or a PIC, maybe? With some mandatory training as a part of it and notification to her employer.
That's where I was thinking.
Sounds pretty good.
You want to take a stab?
Oh,
Go for it.
let's see.
Put you on the spot. That's what you get for speaking up.
I will make a motion. I might need some help with this, but to offer a consent agreement for 1 year of probation, require employer notification. How am I doing? And HIPAA training. 3 hours of disciplinary HIPAA training. I think I got it.
And stipulations that she cannot be a PIC or Preceptor.
and stipulations that she cannot be a PIC or preceptor.
This is for 1 year.
That's my
That's-
motion.
That's
Yeah.
what the motion is right now.
For the time that you're on probation.
Any discussion?
If I may, the profile seems to be a little unclear, so I'd ask that council be required to notify staff who the employers are, because, like I said, the profile is a little unclear.
And I'd also like to add to my motion that she notify both of her employers once identified.
Would that include employer acknowledgement back to the board that they've been
Yes.
made aware?
I'll amend my second.
Any further discussion? Dr. Gandhi?
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Walmsley,
Aye.
Ms. Spark,
Aye.
Mr. Hogan,
Aye.
Mr. Al Nassif,
Aye.
Mr. Anderson,
Aye.
and Ms. Davis is recused. I noticed that this time.
That's good. I was going to get you glasses if not.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Thank you for being present. I have a request to go ahead and take item 21E by staff. We have a request to table this matter. Is that correct, Dr. Gandhi?
Yes, we do, Madam Chair.
Do I have a motion to table item 21E?
I move we table item 21C.
E. E. Elephant. Elephant. Do you have a second?
Second.
All those in favor?
Aye.
Aye. Any opposed?
And Madam Chair, just for the record, as we did get that notification last night or this morning, maybe, one of those 2 time periods. Also allowing the board, the request was also to waive any timeframes associated with this application.
Thank you. All right, Dr. Gandhi, that takes us to your report, I believe.
Let me take a couple of deep breaths here, Madam Chair. I'm going to be here for a while.
Yeah, if anybody needs a bio break, just speak up, because we may not get through all of his before we need that.
Okay, Madam Chair, 26, item A1. As you know, the board gave me authority to do executive director dismissals on cases, and the list is itemized in the packet that we have. But between last board meeting and this board meeting, we dismissed 110 complaints. Some top 3 reasons are allegations were investigated but not substantiated. That's the number 1 reason. Others were customer service related matters. Case was referred to another agency, not in our jurisdiction.
Dr. Gandhi?
Yes.
Miss Davis just told me that she got a text that YouTube can't hear us. So we probably need to take a break and figure out what's going on. Want to recess for 10 minutes?
That's perfect. Thank you, ma'am.
Okay.
was their computer, yeah.
All right, welcome back. Hopefully everybody can hear us online. I think we should be good. Dr. Gandhi, go into your report, please. 26A.
Sounds good, Madam Chair. And just for the record, actually, we have several people listening to YouTube, and I think they were able to, might be just a user error on your friend's part. I'm sorry, but so back to 26A1, 110 ED dismissals. Out of our jurisdiction was the highest one. Referred to other agencies was number 2, and customer service related matters were number 3. Second on my agenda is non-disciplinary orders. Get to that here. Between last board meeting and this board meeting, we issued 3 orders for non-disciplinary civil penalties. Next on the agenda, 26A3. Board has taken up a position about having some uniform decisions on certain matters. And board staff felt that in order to alleviate some stressors during board meetings and pushing the meeting beyond its breaking point, at some of that could be delegated to board staff. Some items of discussion is executing interim consent agreements, issuing interim orders, approving applications with attestations, like for instance, physician owned. If they fill out the attestation, they're not going to prescribe to their own pharmacy. So that's something we can take care of behind the scenes, and then just bring it before you guys to ratify the decision so that we don't have to have them present for 30 seconds and spend an entire day here, wasting board's time, wasting their time, when these things could be taken care of behind the scenes. Some other items, hopefully that could be delegated, is negotiate civil penalties when there's only issues of permitting, doing permitted activity in the state and no other violations or issues. And then take the entire list of the non-disciplinary civil penalty and allow us to take care of those. Again, all these would be placed before you guys to ratify my decision at the end of the day. So if we can discuss and have a motion on that, that'd be great.
Madam Chair, I've got some possible considerations. We get this a lot, and I think for the most part, we've always said yes for the exams for the 5th attempt. Is there a way that goes to you so we don't have to see and have that again?
That one is specifically called out that on the 4th attempt that I get to approve it. On the 5th attempt, they have to appear. So we probably have to amend our laws on that one.
I have a quick question. It relates to statutes. Is there anything in statutes that prevent us or that would be making it look like we're not doing our job in allowing you to have that authority?
I think there's plenty of cases that come before the board today that they're more serious than the ones I'm asking to deal with. But no, it wouldn't create that optic or perception that the board is not doing anything.
I only asked that question because when I'm on the Oil and Gas Commission, we did something similar to this to our administrator a number of years ago, and it was authority from the AG's office. Then they came back a few years later and said, no, we have to undo all of that because of those same kind of issues. It took away authority that was specifically and only given to the board, and the board wasn't able to pass it on. So I just wanted to make sure there was nothing like that in the statute.
I think the safety provision we're putting into place is agendizing it for you to ratify my decisions, right? So if there was ever a challenge, you could pull that out and say, hey, we need to reconsider this. And then we can, of course, try to figure out how to remedy that issue. But that would be the safety net.
I have a couple others. The bathroom. The bathroom deviation request that we consistently get, greater than 100 feet. Is there an opportunity to specify?
I think we can add that. And Ms. Galvin, I sent you that language the other day, and it indicated board or designee of the board, right? So we can probably add this to this list and then get the weigh-in from our compliance officers to see if there's any concern about it being 300 miles away versus 300 feet away.
I would like to revisit the rules. I mean, like, we need to get rid of some of the square footage stuff and just apply common sense. Like, to your point, we never say no, so why do we have the rule? Like, let's just get rid of the rule and put something in there that's like sufficient space, sufficient distance, and then our compliance inspectors can say if they have a concern.
And then the third one that I wrote down in my notes was in regards to, seems like we'll get PharmD graduates that their intern license expires pretty quickly. Either it took them an extra year to finish pharmacy school or what have you, and we always give them a year extension on that intern license. Is there an opportunity to allow the ED to manage that? Those were the three that I had noted as opportunities.
Is there anything here that gives anybody any pause or concerns for what Dr. Gandhi's proposing? Hearing none.
Make a motion, please.
I would move that we approve this with the amendments that member. No, I'm trying to think of something else here. Never mind. Member Anderson
Adding the
brought forward.
bathroom and adding the
Yes,
intern.
and I was trying to be
extending intern
specific,
license.
and I just went blank. Sorry. Thank you.
So the list in addition to the two items.
Yes.
Perfect.
I second.
A motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries.
Next on the list, Madam Chair, is consideration for pharmacist technicians working in unpermitted locations performing duties that required location to be permitted. Over the years, we've had concerns about Arizona Cancer Institute and other facilities that have been hiring pharmacy technicians, potentially pharmacists, and they are possibly compounding in those facilities. And it's not permitted as a pharmacy. And they may be working under the authority of a medical practitioner, but they're still pharmacists. And being pharmacists, they need to comply with our rules and regulations and work accordingly. So I think this needs further discussion on how we manage that.
Perhaps we start with the Rules Task Force. There, get some stakeholder feedback and ideas.
Because we know like there's few pharmacists and technicians, they practice.
Well, and I don't want to limit it. I don't want to limit like
No, but you need
the
the
stuff that
technician.
can be done, like remote data processing and things like that. That's already allowed. But you're right, like compounding should be performed in an appropriate facility. Drugs should be stored in an appropriate facility.
Yeah, when the
that kind
pharmacy-
of stuff.
Right.
That's where I think you're going, right?
That's where I'm going. As far as providing cognitive services, I think that's totally perfectly fine. But when you get into dispensing somebody else's inventory, like a physician's inventory, or compounding practices or something, then that becomes a challenge for us.
Do we need to involve the medical board?
We may have to engage their input on this, yes. But I think initial would be start in-house with our rules task force and then expand it from there.
That makes sense to me. And then get their feedback, and then maybe you can meet with the other boards and get their feedback before we decide to do something.
Certainly.
And Dr. Gandhi, this is nothing to do with work remotely, like if you have a call center or something. This is different.
Yeah,
Like
this topic is more
practice, like compounding or
exactly
Dealing with
dispensing medication
drugs.
Okay.
Yeah, physical activity versus mental activity.
Versus okay.
Yeah.
Would the same be true for veterinary offices that are compounding? Because that happens often. Do we want to involve the veterinary board also?
If it involves pharmacists and technicians being there, then we would have to open up that discussion.
What word covers compounding of vitamins?
In theory, anything that you compound, combine two ingredients, it becomes almost like a prescription product. It's an unapproved FDA prescription product, but it's a prescription product. So it should fall under our jurisdiction. I know physicians have authority to compound based on the FDA laws. And according to the medical board laws here in Arizona, they can delegate that task to basically anybody they want, but we also have oversight over certain licensed people.
Do we have many facilities that do that here in Arizona for vitamins?
We don't have the volume of, we know it's happening. We don't know the exact volume of the number of entities involved, but it is happening.
I brought that up only because I was leasing a building at one point, and that's what they did in that building, and it was so polluted in the vents. I mean, we had to really go through the whole thing to redo it. It was not good for the people that worked there.
I mean, the IV hydration space is rife with that stuff right now. I mean, you see casinos in Vegas and stuff like that that have people that are making just what is a compounded product that's going to be injected into somebody's body, very similar to what you're talking about.
Yeah.
I've seen a NABP model language surrounding that kind of med spa
Yeah,
facility.
that's new. We're going to talk about med spas in a little bit.
All right, so rules task force, I'll agendize it for that.
Thank you.
Next
Oh,
on
I
the,
owe you dates.
yes, you do. Next on the agenda, we had an individual present at the last board meeting, Mr. Bearcat, saying that right? Presented a packet to the board members to evaluate gabapentin to be a controlled substance. It is a mind-altering medication. It is being scheduled in many other states. That's something for this board to consider going forward. You have his packet in your board book. And he has a valid argument.
For the record, I do know him. I've worked with him in the past, but it does not impact my judgment on this case. But I do want to make a disclosure there.
So when we talk about gabapentin to be a controlled substance in the state of Arizona, so that require changing labeling, like from manufacturer labeling to put like control schedule 5 or 4, whatever we decide, or
If Arizona deems it to be a controlled substance,
yeah,
then the manufacturers would have to
who
adjust their labeling requirement.
I appreciate what he has submitted, but I would love to see more evidence. And I do know that other states have done this, and I'd like to see outcomes data on, what has happened based on rescheduling. Have we impacted and improved public safety by rescheduling it? Or is it, comorbidly used with opioids? I don't know. I think there needs to be more data that needs to be assessed than just his well-written but anecdotal report.
yeah, I mean that's important. I mean, like I kind of like leaning to yes, agree with him, but also we need like more data, because when we control it, might cause more harm sometimes than good.
Is an alternative approach that we could look at having it reported to the PNP to at least have to get some more arms around it, and then Doug's team could look at data, and then we can start to see what's happening with the medication and if there is any type of incidents, because I think he looks at like coroner's reports and all kinds of stuff, right?
That could be definitely discussed, and I can touch base with Doug after the fact and see how we can get that.
Because I think that's an easier change. I don't even think that necessarily requires rulemaking, does it?
If we wanted to be reported into the PMP, would require some sort of, I don't know if it requires a statute change or a rules change. Right now, I know we do have the authority to adjust our scheduled drug list. We already what's in a CFR. But we could add to it in the rules package. Requiring something to be reported at PMP may require a statutory change.
I mean, like looking at more data is definitely will help all of
Yeah.
us.
Yeah.
And like for example, now clonidine, they're talking about people abusing clonidine, right? And then we need more data, right? We cannot just control every single thing. But I support the idea 100%.
Is there anything, I know we have in the past supported the Poison Control Center in Tucson. Is there any way that we can get them to help review some of the data and the literature that's, the contemporary literature out there about these states that have scheduled it? Is there data, published on improved outcomes by scheduling it that perhaps they can synthesize and help present to this board?
We can certainly work on that, Mr. Anderson.
I think that's a good next step, is for us to do a little bit digging. It looks like there's more states that require it to be reported to the PMP than schedule it from just a quick Google search, but looks like it's about half the states that do one or the other. So I think looking at something is not a bad idea. Just what's the best approach to accomplish what we need, I guess, is the question.
Would that cover dosage? In other words, is there a maximum a person can safely take in a day, or is it of the gabapentin?
That should be in the manufacturer's data on the minimum and maximum levels that someone can take. That's already published, Mr. Thorwald. Anything else on that, Madam Chair, board members? Okay. Next one on my list is we have pharmacies that are non-resident. They hold a non-resident permit with us, and with being non-resident, individuals that work in those facilities don't have to be licensed by us. The challenge here is, I think we just had a recent case where a pharmacist was involved in an error, and we pretty much don't have authority over that individual. We have authority over that pharmacy, but we have unprofessional conduct listed under pharmacy acts, and some of the ones listed under pharmacist don't translate into the permit holder. So how do you hold a permit holder responsible for a pharmacist action? My initial thought is, since this was a decision and outcome that the permit holders wanted, that they would assume the responsibility and actions of the people working in that building. But that could always be challenged. So I'm looking for direction on how we want to manage unlicensed individuals going forward. Several years ago, we ran into issues with entities working without a permit, and we ran an unpermitted bill to hold them accountable, just like we would if they were a permit holder breaking the law. So I don't know if that's what's needed. Obviously, I don't want to license everybody in the country. That's not the recommendation.
No, and I don't think that would be a good precedent. There's nobody else that does that.
Yeah. But do we look at unlicensed activity and we can hold them accountable in that sense? I don't know.
I remember this was at Ohio Pharmacy and, Protopium albuterol nebs. And I remember Mr. Morris sharing something at the public call to the public saying, we certainly do have the authority to do that. So I'm just curious what his opinions are on how we can keep that permit holder accountable for those the staff that we would normally deem accountable to the issue. I vaguely recall him saying that.
I mean, I think our current language around non-resident matches the NABP Model Act. I don't know if we want to open up a discussion. I think I would prefer if we start with the rules task force and maybe broaden it to some of the folks that have a lot of non-resident pharmacies. The company that I work for does have a lot, but would certainly like other people's perspective as well. before we look at potentially any changes. I don't know that there's a problem. It hasn't really come up very often is kind of where my head is.
I think one thing that could help Dr. Gandhi is the compliance officers, when they provide their documentation to the board, is on the permit, it always says to be determined by the board. And then I think that if there is a violation potential noted to the permit holder on that summary, it helps us connect the dots better. I don't know if that's an opportunity too.
We can certainly look at it, and I had some discussion with my counterparts across the country. And in this case with Ohio, they have the opportunity to go after that pharmacist. But there are a lot of other states, if that action happened in Arizona, they don't have jurisdiction to take action against that pharmacist in their home state for something that happened in Arizona. So there was a mixed bag of answers. I'm like, hey, how would you approach this? How would you approach this? And that was the answer I got.
Do you think the UPHA, and I know we're going to talk about that in a little bit, do you think that that plays a role in this discussion? Because my understanding of the way that NABP is going to look at it is kind of like their state endorsements. So is that an opportunity to kind of close some of this gap too? I don't know.
Could you just refer the pharmacists involved to their own state board?
We can, but it's a mixed bag. Some can take action on what happens in another jurisdiction, others cannot. So it depends on the state.
Is there any kind of interstate compact that that could fall under?
So we don't have a compact. We call it reciprocity, which is similar to a compact where pharmacists can freely move from state to state, but they have to take the law exam for that state because of nuances and stuff. So yeah, compact is a common terminology used in nursing board and other boards. We have adopted the word reciprocity, which is very similar to compact.
But a little more complicated because of the law exam.
All right, so rules task force on that one?
Yeah, let's start there and see what ideas and see how the public feels about it.
Perfect.
Give others the opportunity to speak up.
Next on my agenda is in your board book, you have a draft version of rules pertaining to transferring of prescriptions. I've reached out to the governor's office several times now. I haven't gotten approval to move forward, but I think if you guys approve it, I can continue to nag them until they give me approval to move forward, and we can get this thing going. But in essence, the DEA has been a little more flexible around transferring, like especially electronic prescribing or transferring of controlled drugs. And our rules are a little more strict. So the goal is to align with the DEA so we don't have two sets of rules or we're not as strict or whatever. But if you haven't, please take a look at it, and I'd like your opinion and hopefully approval to move forward with it.
I looked at them when you were drafting them, and I think they look good. Obviously, they'd go out for public comment and all those kinds of things just to make sure that we have another set of eyes on them. But I'm supportive of it and think it's good. And the faster we can move on it, I think it'll help pharmacies and help patients. So I don't see any reason why.
Absolutely. I also think it looks good as well.
So my two asks would be approval to move forward with rule writing process, rulemaking process, opening a docket and so forth, getting the governor's approval, and approving the language that's in your book.
So do you need a motion? So I move to just approve the change. That's what the motion you're looking for? Approving the change you made, or?
Approve me pursuing rule writing process.
Rule writing, okay.
And approving the rules package that's.
Package that's submitted. Yeah, that's my
Second.
motion.
Second.
A motion and a second. All those in favor? Aye.
Aye.
Any opposed? Hearing none, motion carries.
Next in your package is the update on the immunization rules package. GERC did vote on this to be effective immediately. So the rules package for the immunization that you guys had approved is effective. It was effective as of last Tuesday when GERC had approved it. we will post the updated rules package as soon as Secretary of State stamps it and gets it back to us.
With this, there's any updates or change?
Nothing. It mends what, or it codifies what we did in emergency rules late last year because of ACIP.
Okay.
Yeah, it expands the ability to use a standing order
Yeah.
when giving immunizations. So in essence, that's what it is.
Okay, thank you.
Any other questions on that? Next is, I know we've been challenged with technicians coming here before us and then showing competency for technicians that constantly break the law or that haven't practiced in a number of years. So I had reached out to PTCB, and PTCB had a sort of a solution. So if they maintain their PTCB, they cannot retake the PTCB exam. They'd have to go the other way, which is the NHA exam. The alternative way to take PTCB exam is let their, I guess, registration or their activity being active with PTCB expire. If they let it expire, then they can take the PTCB exam. The reasoning behind it is because of integrity of the exam, integrity of the questions, and so forth. So they don't want people to repeatedly take this exam and collect the data and then post it somewhere. So if we were ever to discipline a technician or prove competency, PTCB may or may not be an option. So this is more informational for you guys. Any questions on that? Next is a hot buzzing topic across the country, the UMPJE. It's a universal multi-state jurisprudence exam. So if you take the UMPJE in one state and other states have adopted the same, you're able to reciprocate to that state without taking another law exam. So it becomes a form of a truer compact, I guess, per se, than what we have today. There are some concerns. We have some nuances in this state. All the states have certain little caveats to their laws that are different than other states. So then how do we catch up the individuals on those nuances? I know many years ago we eliminated the requirement for the law CE in this state. I don't know if that's something we want to put back in to then allow maybe AZPA to run some programs that only talk about Arizona law and the differences or whatever, so that knowledge is still shared with the practicing pharmacist out there and not lost.
I think it's important that they know what the Arizona law is, and that needs to be included in whatever is done, because if they don't, they certainly can't follow it and we can't hold it to them.
So a little more background on the UMPJE is what NABP is doing is they're capturing the most common laws across the country. And then they're putting that in an exam. And then they're taking the federal law, which is consistent already, right? And then that's in the exam already. So 90% of laws across the country are pretty standard. We're talking about 10% variance, if that. And that could be potentially captured with CEs or something like that.
I think it's good as long as it's captured, the differences.
I mean, no other medical profession really has a law exam.
exam.
And it's sometimes a barrier for people to work upon emergencies across state lines and all those kinds of things.
I mean, I totally agree.
Are you asking for our opinion if this is a direction we should go?
Asking for your opinion and discussion, and I know this is a movement.
I mean, getting like more CEs or like add 3 CEs or flaws. So our 30 hours of CE required is becoming so structured. Like, you have those for immunization. This is for laws. Like, I agree with you. Like, people who practice in Arizona should be aware of our rules or those unique rules to Arizona. but I believe this is their responsibility. I mean, like if you test someone today and they pass it, it doesn't mean like they're gonna follow it or know it, right? I believe they can sign acknowledgement that they're aware of the state of Arizona rules and they cannot follow the rules. That's how I see it.
Well, we have the MPJE today,
Yeah.
and we still see matters
It's
before. us.
exactly, you know what I mean?
And
don't
I
know
can,
that-
I can argue both ways.
Yeah.
Either way, but,
I don't know that a test really makes somebody follow the law. I mean, there are other states that use an acknowledgement. To your point.
Yeah.
I don't know.
But the first question, there is any reference for this new exam? Like now with a new graduate, there is a book for them to study to pass this exam, or there's just this unified exam?
I mean, they're still finalizing the blueprint right now,
they are.
which it should be done in May. The last
The
time I-
first round of UMPJE states is in April. If the board directs us to adopt the UMPJE, we could potentially get on the early adoption list.
I mean, we don't have an opportunity to not have the MPJE without any sort of legislative change, right? Or is that,
No, it's in
is it rule?
Rules, yeah.
Our statutes and rules
One or the
actually
other.
generically stated that board-approved jurisprudence exam, so it's very broad. We define MPJE, but it's not. The requirement to be licensed as a pharmacist is a board-approved jurisprudence exam.
So we couldn't eliminate the need for a jurisprudence exam without a statute change, but we could adopt the
Correct.
UMPJE instead of the MPJE.
That is correct.
We're gonna keep them both, like one or the
I
other.
think it makes sense to try to do the UMPJE.
Yeah, I did check with NABP whether you could do both. If you wanted to do both, it'd be a later adoption. Right now, NABP would not have the capacity to run both exams.
Oh.
And then I don't know if it makes sense to run both.
Jen?
I just wouldn't want anyone who's already taken it, who still hasn't maybe passed the NAPLEX or something like that, to not be able to take it
Mhm.
or use it. So maybe a time where we would accept either one. Maybe.
Like the first year or something like that.
Yeah.
Well, if they took the MPJE today and they passed it, it's good for 2 years. So maybe allow for 2-year expiration date if they've already taken it. And today would be the cutoff, or whenever you guys direct us to have the cutoff.
I'd like to be an early adopter. I think it makes sense.
I agree.
I agree also.
I also agree.
Okay,
Do you need a motion?
I do need a motion.
So moved.
I'm like, somebody
Second
wake up.
remove.
So I'll just restate it real quick. The adoption of UMPJE, it's gonna take a little while for us to get used to that, but, and then of course have a grace period that if you've taken the MPJE, it's gonna be good for 2 years. And then we'll kind of set an expiration date. What are we in, February 11th? The UMPJE will not be in effect until April. If I can get us on the early adoption list, maybe have a cutoff after April, but if you can leave that up to me, I would appreciate that.
I will modify my motion to reflect that.
Second modified.
I just say something about the sample question, because I don't love the sample question on, it basically says that if something's on the FDA drug shortage list, the pharmacist must, the correct answer they say is compound using the prescription using FDA approved products. API isn't FDA approved.
I already raised that.
Okay.
And they will adjust that. So
I was like, this is
not
a bad question.
Yep. I looked at that and I didn't like it either, so. Okay.
And I'm sure NABP would appreciate additional item writers that could put their eyes on it with compounding expertise. Right? Is that
They would.
fair?
They
Uh,
would.
So-
They're always looking for.
They're always looking for people. So like if you want to provide feedback, I'm sure they take your feedback on questions, Danielle, seriously.
I just looking at the area, they gonna ask like DSCSA, NIOSH, OSHA, and all, you name it, right? new graduate, they don't know a lot of this because they're really focusing on study and clinical practice. Like if you ask now a new graduate, hey, tell me about DSCSA or tell me about NIOSH list or USB 800. It's good. I mean, it's good for people to know and study about it, but I expect to see like less passing rate than recent exam.
The federal rules today are already being tested. So it's on the MPJE today.
Yeah, but it's going to be more focused on this, right? Like common federal rules.
Common
Yeah,
rules
no
across the
questions,
country and the federal law, yes.
So along those lines, a new graduate, if they, will they have a study guide for the unified, or should they just study
That's what the question.
the M?
I'm sure there's going to be updated resources available. I don't know where all the
And so we should communicate that. I think my point is, I would want to be sure that folks that are going to get ready to take the law exam, whatever the law exam is, that they understand what they're taking.
Yeah, Cam, I guess if we could direct you to reach out to Mary at Midwestern and
I'll reach out to both
Paul
universities.
Lipsy at U of A to make sure, and I don't know who teaches it at Creighton, but make sure that they know that this is the direction we're going so that they can make their adjustments too.
They've been reaching out to us, so I'm sure
Okay,
they're.
I know the schools, I know the schools are interested in this.
Yeah.
There's a lot of talk about it at various meetings I go to, so.
So we had, so moved.
Yes.
We voted, I believe.
Did we vote? Could I?
We have a second.
Mr. Thorwald did.
Yeah, and I think we were a unanimous vote. We can vote again. All those in favor?
Aye.
Aye.
Just as an exclamation point.
Any opposed? Unanimous, Cam. Unanimous. You're keeping track.
Do we have to address your, not necessarily suggestion, but, for us to consider requiring a CE in pharmacy law, Arizona specific, or request AZPA to help work on something like that? Is that appropriately agendized here based on what you said?
I don't see, me personally, I don't see a
It's-
reason.
it's-
They passed a law.
Yeah, we got rid of Law C, so there's no requirement to have it. I don't know if there's an incentive since there's no requirement for AZPA to even work on that.
Okay.
So,
Future agenda item?
yeah. Next on my report is NABP tested out this in a couple of states about having a pharmacy student take the MPJE early after they do their curriculum before they graduate. So in their last final year to take the MPJE, and the rules were around you're allowed to take it once early, and if you pass it, great. If you don't, then you got to wait till you graduate and take it sometime after you graduate. It's worked out very successfully because now you got the biggest hurdle or one of the hurdles out of the way early. Now you can focus on the NAPLEX after you graduate. Seems to be an appetite that's growing just for that reason. I don't see a reason why we need to hold it up. And I think, Gene, I shared some language with you, which I think doesn't require us to modify our rules or anything of that nature. And we could adopt to take the UMPJ or MPJ until whatever time earlier before graduation.
How soon would we be able to start that? I cannot talk.
That I won't know until I
Talk with
to Paul on
NABP.
Friday. Yeah.
I mean, I've talked to schools in both of the states that did the pilot. I've talked to both of the boards, and I see absolutely no drawback. There's a challenge, especially in the residency space, with people passing both of the exams and the appropriate time to be able to finish their residency programs, which companies and schools are investing a lot of money in trying to do the postgraduate education. So I think that this is something that could be helpful, and I don't really see a downside to it personally.
again, I think what we'll draft our internal policy to be is to adopt NABPs, which is allow them to take it once. If they fail, then they have to wait till they graduate and then attempt again. Yeah, and all the reviews I did with NABP and their numbers is out of everybody that's taken it, there was only one failure, which isn't too bad. Percentually, that's really huge.
And I think it potentially gives, Arizona a leg up on potentially people wanting to come to Arizona to get licensed sooner, which could be good for the public. I think it could give some of our residency programs preference. Not that that's our goal in this, but I like I said, I see no drawback. Do you need a motion, Kim?
I do, yes.
All right, I'll try this. I'll make a motion that we adopt or we draft language allowing pharmacy interns to take the MPJE or future.
Yeah.
Once.
We don't need to draft any rules.
Okay.
Actually. We just have to kind of adopt what NABP has in place. And we'll draft our policy accordingly.
I will make that my motion.
And that's the motion. And to answer your question, Madam Chair, I think it's July 1st is when we can implement that.
Okay.
Second.
A motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none.
The next on the list is requirement for reciprocity with pharmacists that have only taken the MPJE in another jurisdiction. And this is more informational only, Madam Chair, no votes or anything needed. But if they've only taken the MPJE in another jurisdiction and we, after April, we'll assume April is a go live for UMPJE, they will still have to take the UMPJE for our state. And then of course, then that test is movable to any other state that adopted UMPJE. So just throwing that out there. Any other questions?
Do you need a motion on that one?
I don't need a motion on that. Next on the agenda is just a reminder, there's an NABP national meeting coming up in May. It is going to be in Boston this year. So we need to vote on who is going to be delegate, who's going to be alternate delegate.
Who's planning to go, I guess. I will start the conversation. I am planning to go. I do not think that I should be the delegate as I am the candidate for the district for the executive committee. I think that would look bad if I was the voting delegate for our jurisdiction. So
I cannot nominate myself. I'd like to go.
who else wants to go or is planning to go? We can get one scholarship, right?
It's
Kim?
actually broken up into 2 scholarships this year. I
We
think
can
they
get
upped
2
the-
scholarships.
They upped the ante to, I think, 2,500, if I remember. May not cover all the expenses, but helps cover a majority of it.
So I would like to go. Me.
I would also like to go.
So
So you guys want to fight for delegate and alternate delegate?
it doesn't
Arm-
matter to me.
Arm wrestle?
I take the more scholars.
As long as I get Arizona's vote.
As long you pay for it. As long you pay for it, Cam, so I'm fine.
I'm good either way.
Right now.
Well, we have to decide.
Who was it?
So I was a delegate last year, so she will become the delegate.
Okay.
How was that? See, I'm fair. I'm not selfish.
So I'll make a motion that Stephanie is our delegate and Tariq is our alternate delegate. Do you both need scholarships or should we extend those to other board members?
No, I will take the scholarship.
Okay,
Yeah, I may need that.
okay. My company will pay for me to go,
Yeah.
so.
I'll touch base with them individually and see what we.
Do I have a second for my motion?
Second.
A motion and a second. All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries.
And just for my record, anybody else going besides Lori?
But it's
And then I assume we'll have some staff there. Obviously, you'll be there. We usually bring a few compliance officers.
Yeah. Okay.
Yeah, I'll be there. I have to be.
And I'm running for treasurer, so I have to be there.
That's true. You'll get to hear our candidate speeches. So Cam will also need a vote in support.
Yep.
Not that we're campaigning today.
We don't have buttons yet. We have to get some buttons.
Should we be on one ballot together? Like a dual button?
I have a button maker at home.
Okay.
All right, the next agenda item is probably going to take some time to discuss, Madam Chair, and I just put it on the screen here. And some of it's color coordinated, and you'll see on the left side of the screen, it's a different color that kind of stands out. And those are the bills that I want to discuss today with you guys. I also need a position from the board on how they want us to proceed with the legislators on if we're opposed to it, if we're for it, or if we're going to stand neutral. Some of the ground rules are we don't take positions on expansion of scope, expansion of business models, or anything of that nature. We do take positions on safety concerns, direct safety concerns of the general public, and how the operation of the board may work at that point. So I need you to definitely take off your work hat and put on a board member hat for this discussion. The first bill is ivermectin. The position here is, not the position, but the summary is Arizona proposed allowing ivermectin when formulated for human use to be sold as an over-the-counter drug without a prescription or pharmacist consultation. There is a little provision in there that says, and if authorized by federal law or something of that nature. So there is a caveat in that bill that federally it's a prescription only drug. So I don't know how they can circumvent that, but that is up for discussion.
So if this bill passed, so same thing, we need the manufacturer should repackage to meet the OTC packaging, correct?
They have to get FDA's approval.
They have to get the FDA approval.
Yeah, to relabel it.
To relabel
Because FDA has authority over the counter and prescription drugs.
Okay.
And the labeling requirements for that, so.
So you're saying that caveat is in the bill currently?
Yes.
Do you expect any shenanigans to take that out last minute?
Don't know.
I personally have patient safety concerns. We saw, it's, in my opinion, it's a legend drug for a reason. We saw some cases during COVID where it was prescribed probably on too high of doses that would have caused patient harm. So for that reason, I'm concerned about the impact to patients not having proper supervision with the product. And if the FDA decides to change it, then the discussion's not going to matter.
Totally agree. I oppose high risk of dosing errors due to weight-based dosing and indication-specific dosing, known toxicity with misuse, including neurologic effects and hospitalizations. Totally agree that we should oppose this.
But I agree that we should oppose it as well. It also becomes a slippery slope in terms of why have any legend drugs at all. I mean, I don't see why this drug is in a different category than 99.9% of other legend drugs at this point.
And if the FDA decides that it's safe and wants to put it over the counter, then they'll look at that safety data. I don't think we should look at that within the state.
I think we should oppose this bill, but I'm just going to play devil's advocate for a minute because people can buy ivermectin at feed supply stores, and there's a lot likelier chance of someone accidentally overdosing on horse ivermectin than 3 milligram ivermectin tablets.
Do your own research. Is that what is stated? So if people want to do that, they should do their own research. I think our role is to protect the public relative to prescription drugs.
I mean, we have people that bought fish fluoroquinolones too. I mean, like, I don't think we're ever going to stop some of that.
Yeah, and they ended up in my hospital. Yeah.
I see that 4 other states have already passed this. So Arkansas, Idaho, Louisiana, Tennessee, and then they're working on it in Texas, North Carolina, New Hampshire, West Virginia. So if we had any feedback from the 4 states that have already passed it.
I don't think anybody has implemented it for the reasons we've already discussed.
That is correct. From
So nobody has
my
done that.
initial discussion with some other executive directors. Okay, so board's position is to oppose. Do we need votes on these? Ms. Calvin? Okay,
Yes.
Yes.
anybody in favor of it? No, okay, good. Next one is House Bill 2139, Public Records Response Requirements in Complaints. Custodian is to provide response within 15 days and provide a time period on when the request will be fulfilled. Provision for immediate effective date. This is problematic. We get quite a bit of public records requests. And JM here is my gatekeeper for that. There have been some very robust public record requests where we need to get ADOA involved, which can dissect our emails and pull information, and then we have to make sure we redact information that's private and confidential. And that could take quite a bit of time. So for me being the custodian of records for this agency, being able to call out a certain time period to disclose and release records, it could be problematic because I don't know, I can't control what ADOA does, how soon they get me that information. For that reason, it is problematic.
Is there currently a time requirement?
It's
And
reasonable. It's reasonable time, and we try to get it off our plate as fast as we can. I don't have a concern with the acknowledgement. We do acknowledge that we have received your public records request. Putting all that information together and getting it back to them, majority of the time, that's not a problem. But a handful of times, that could be a problem.
You just don't want to set your team up for failure, which
Exactly.
I respect.
So, oppose with the concerns presented?
Yes.
Agree.
Agree. So just thinking a little bit more about that, the flip side is an allegation of bureaucracy and just an ultimate failure to respond, and nobody can be held accountable. Can we think of any way to kind of dispel that or resolve that type of accusation? I don't know if that's some outer limit number that you'd be willing to back into, or whether it's not that big a deal.
So some of these bills that are health board related bills are not directed at us solely. It's all agencies. And there may be some agencies that aren't performing as well and some agencies performing awesome. I don't know where we fall in that spectrum. I want to say we're awesome, but I don't have the numbers for the other agencies. So from speaking for our own agency selfishly I think we do a pretty darn good job to respond to these public records requests. So I don't see a need for us to change anything. Any other questions on that? Next one, I'm not going to go through all the itemized bills I have on the agenda, but I'm going to go over the highlights. House Bill 2208, Health Board's Violation Investigation. It authorizes the Arizona Attorney General at the request of one or more legislators to investigate actions by health professional regulatory boards alleged to violate state law, rules, or the Arizona Constitution. If the Attorney General has a conflict of interest, the complaint must be randomly referred to a county attorney. The written investigative report is required within 30 days and must be distributed to state leadership and the legislators. If violations are found, the Joint Legislative Budget Committee must review the report and recommend any appropriate budgetary changes within 90 days. This one's an interesting one because we have two members of the Attorney General's office sitting at our table today. And they're giving you legal advice. They're giving you, if you're stepping out of line, they're slapping your hand and so forth. So for me, challenging our actions to the Attorney General's office kind of defeats the purpose of having, having our, I guess, watchdogs here. Kind of puts an egg on the Attorney General's face, saying, hey, if anything, why aren't the Attorney Generals sitting at the table with the board members doing their job? And keeping the board members in line. The other safety mechanism we have is, of course, we have public members to remind us that, hey, you guys are not here to protect your interests, but protect the public. And then we also have other safety features of the governor's constituents office, the legislative body, the ombudsman's office that monitors or that could receive complaints that we're out of line. So there's already a lot of safety measures already put in place to make sure we are acting in our space, in our lane. This is unnecessary.
I think it should be opposed myself.
I agree, Mr. Thorwald. I oppose.
Online.
Oppose.
Oppose.
Dr. Gandhi, I have a quick question before you proceed. So on any one of these that, for example, we oppose or support, what do you forward that position to the legislature? Do you wait to get asked? Is it put on our website? How is that communicated to the general public?
So on a weekly basis, bills are posted to be heard in the House Health or Senate Health. And that's when our opportunity is to chime in, to say we oppose, and to speak to the legislators that are there to say this is the reason why we oppose this bill. Now, it could still pass even after we oppose it, right? So
Do you show up to those meetings?
I'm the registered lobbyist for our agency.
Okay, thank you.
Yes.
And you sign in and take positions too, where we have a position on the system, right?
That is correct. House Bill 2209, Health Board's Retaliation Prohibition, prohibits health profession regulatory boards from retaliating against health professionals, applicants, or related individuals for whistleblowing, cooperating with investigations, refusing unlawful conduct, or seeking legal counsel. It creates a strong legal framework shifting the burden of proof to boards once retaliation is plausibly shown. The Attorney General and County Attorney may investigate and enforce violations, and protected individuals may file civil lawsuits. Available remedies include reinstatement of licensure, record correction, injunctive relief damages, civil penalties up to $25,000 per violation, attorney fees, punitive damages. The bill also mandates confidentiality for whistleblowers. Thoughts?
For A number one, making or attempting to make protective disclosure, does it mean like if someone reach out to the board staff, say, hey, I witnessed diversion or I was part of diversion, that will consider a whistleblower and will be protected? You know what I mean? Like,
I think that's how I interpret it.
yeah, I mean, like, so if if I notify the board about something I was involved, I did the mistake, so now I'm protected. That's how it sounds to me. You know what I mean?
I personally think it should be opposed. It's already under federal law.
Other thoughts?
Okay. Is the position to oppose?
Everybody good with that?
Yes.
Speak now? Okay.
Next one's not necessarily highlighted for discussion, but it is worthy of a discussion. House Bill 2415, Kratom products, narcotic drugs. For those that are not familiar with Kratom, it is on a low dose, it acts as an amphetamine. As a high dose, it acts as an opioid. Soccer moms use it. People that are on substance use disorder, that they don't have access to oxycodones or Vicodin, go to Kratom to curb their appetite for opioids. States, there are a number of states that have already positioned hydroxy version of Kratom to a Schedule I category. And there's other states also moving in that direction. The two bills that are presented in Arizona do tighten up the laws a little more, but not to the extent to schedule the hydroxy component to a Schedule I. So I'll open it up for discussion.
This is good.
I'm personally supportive of scheduling it. I think it's a continued growing area of concern. The fact that other states are scheduling it also makes me a little bit nervous. I don't want to become the supplier of Kratom for the country if we don't do something about it, because there's certainly some evidence out there that shows that it is dangerous. So I would be in support of the bills that create scheduling for it.
So the problem is there aren't any bills that are scheduled. They're tightening up Kratom, but they're not moving to a level of scheduling. So my proposal to you guys is that we support the legislative as it sits,
And
but
suggest-
also add a asterisk saying we would like it tighter and more stricter to be Scheduled I for the hydroxy component.
That makes sense.
I'm supportive of that.
I am as well.
Me too.
Agree.
I think my other ask is, I think, Madam Chair, you may have a connection to Senator Shope, who is sponsoring this bill. If the board, I'm asking the board to allow Ms. Walmsley to have maybe a discussion with Senator Shope if possible.
Yes, I'm a constituent, so.
Yeah.
Approve.
Yep.
Ms. Galvin, any concerns? If the board directs me to do so.
Okay, I think we have a consensus. The next bill is the board's bill, one of the board's bill, House Bill 2434, Controlled Substance Prescription Monitoring Program. It updates the Arizona Controlled Substance Prescription Monitoring to improve oversight, compliance, and public safety. The bill expands data collection to include dispensing and consumption information. It actually doesn't. It eliminates the word consumption from the bill because there's no way to track consumption. The other thing, and I'll just start paraphrasing a little bit, is what it does is also it remodifies the existing task force to repurpose it to a kind of like another task force. The initial task force was designed to build a PMP. PMP has been almost in place for 2 decades now. And so there's no reason to have that task force to build a PMP because it's already there. So the question is, what's next? And the next thing is there's a mandate to check by prescribers. There's a mandate to check by pharmacists. And so what do we do when a prescriber doesn't check? What do we do when a pharmacist doesn't check? And then what are the next steps? So this task force is that next evolution about the next steps on non-compliance of the PMP. So that's kind of presented in this bill. The other thing presented in this bill is capturing 2 data points. One is when the prescription is filled, because right now it's very, it's not clearly defined what the definition of filled means. Is it when it's filled by the pharmacy, or is it when it's dispensed by the pharmacy? So we're going to be capturing 2 data points about when it's actually filled and ready to be picked up and when it's actually picked up. This will alleviate some tension with prescribers because prescribers write prescriptions saying, do not dispense until such and such date. And then we'll get a phone call because the pharmacy reported the date they filled it, not the date the patient picked it up. So that creates some angst, not just with the prescribers in my office, but then we're investigating a pharmacist that may have dispensed it early. And now we're going in there, and when I see the board coming, it's like an oh shit moment. And we're kind of alleviating that as well, right? So we're kind of helping all parties here by capturing 2 data points and having a clearer picture of how that prescription was managed from fill to dispense. Does that make sense?
Yeah, it does. I don't know if this is gonna add anything, but
So Dr. Gandhi, Madam Chair brought up a good consideration for our previous topic on gabapentin. Is there room for language at this stage in this bill to allow reporting of a non-controlled substance so that if we decide to go that route, we've got language to support that? I don't know if we're too far along or.
We may be too far along in this to incorporate that. One of the things about this bill is majority of the bill was driven by the Auditor General report. So it's kind of carved out and saying this is why we're needing this language. So it's in a different bucket altogether. Entertaining gabapentin can certainly be done. I'll have that discussion with the representative that's supporting this bill and see what we can do with it.
Just like for reporting both data, filling and dispensing or sold, I mean, that also require discussion or like time for people to be compliant, because some system built to report when you fill, some of them built to report when it's sold, but it's going to be a different monster, right? So you're here.
Good afternoon, board.
So yeah, I want.
Doug Scavarla, CSPMP Director, and I would say that an implementation date on that would need to be delayed a little bit to allow the pharmacy to be prepared for it. Those fields already exist in the ASAP standards. So did I answer your question?
Yeah, it is answer my questions.
And while I'm here, you know, I listened in on the previous gabapentin discussion. ARS 362608 is our statute that talks about reporting requirements. And the way it's written, it points back to statutes 362513 through 362516. Now, what that is Schedule 2, 3, 4, 5. Because gabapentin doesn't fit into any of those. The question earlier was, can we do it in rule? Can we do it in statute? I don't see a way to do it in rule because the statute itself is. So that takes us to Mr. Anderson's question, and that is, you know, can we work it into this bill? You know, I know Dr. Gandhi will investigate. You know, my concern would be we're putting something very controversial into a bill that's been hard to get to move along. I'm not sure that that's maybe the right thing at this time. And my logic would be, you know, Mr. Anderson said he'd like to see more data. Well, we don't have time to get all that data and talk about it with a legislator when our bill's already been introduced.
Right. I guess my comment was more generically, can the language that at the discretion of the board add legend drugs to RX-only drugs to that list of reportables, not specifically gabapentin, because I think that was my point.
We can certainly have that discussion, but not tied to this bill. Any other questions on that? So would I?
Thank you. That was very helpful. Thank you.
Our ask is that we support this legislation.
I mean,
Everybody good with that?
Yes, I support.
I support that.
Agreed.
The next one is House Bill 2444, Pharmacist Independent Testing and Treatment. This bill has been run for a number of years now, and I don't know where it's going to end up this year, but you may have heard about this bill historically. I don't think we're in a position to chime in, as I kind of presented the rules early on about expansion of scope, but we will keep tabs on it. Next bill I'd like to talk about is House Bill 2660, Health Board's Licensure Decision Investigation. It tightens and clarifies how Arizona Health Professional Regulatory Boards handle investigations, discipline, and licensing decisions, especially when a provider's ability to practice is at stake. The bill updates disciplinary standards for chiropractors and naturopathic physicians, emphasizing conduct that poses a direct threat to patient safety and refining investigative enforcement procedures. Most notably, the bill creates a new statewide rule for licensure action. If a board takes action that is detrimental to a health professional's license and criminal charges are pending, the professional must immediately stop practicing until the case is resolved. If no criminal charges exist, the board's action is automatically stayed during appeal, allowing the professional to continue practicing unless the board promptly substantiates its case with detailed sworn documentation. The legislation also adds legislative and attorney general oversight when boards fail to meet these requirements, reinforcing due process while maintaining public safety. Thoughts on this one? Ms. Galvin, don't we already operate in this fashion? We don't use the word stay, but
Don't use the word stay.
we don't use the word stay, or we don't stay in action. We may do an interim consent decree or
A final order, you could have like a stayed revocation and then impose probation.
but for charges. I mean, unless it's an egregious charge, right? We'll take action, we'll do an interim suspension, something of that nature. And if all those charges are dismissed, I think the board moves to a position where they lift the interim suspension and everybody goes about their business. So reading this through, it seems like we already operate on this level.
I don't disagree. I haven't read the exact text of the bill, but based on the summary, I would agree with you.
So are you asking us if is your suggestion to oppose?
I think so.
Any concerns, board members? Hearing none.
Next one is House Bill 2687, Medical Board Case Review. This one's an interesting bill as it gives the medical board authority over all healthcare professionals. In an event, there was a fatality or egregious action by a licensee. That's the summary.
So it would give the medical board jurisdiction over a pharmacist?
That's essence, that's what it's saying.
So is it the MDs or the DOs?
I think they're both on the board.
They're different boards, aren't they?
Oh, they are. This would be the medical board.
It's the
MDs are superior to.
That's.
This is my concern, like, because they're already behind way more than the Board of Pharmacy. That's the last report from general auditor. They already behind month and maybe a year in a lot of cases. Adding this task to them, I believe it's not gonna solve. It's gonna make it more difficult for them and for some cases. So me personally, I oppose to this.
Mr. Anderson, it's not just a DO board, it's pharmacy board also. We're under the definition of healthcare professionals.
I think it should be opposed. The medical board doesn't have an investigative staff to look at all this stuff anyway. And
they don't have experience.
Respond to complaints, they aren't proactive at all.
Note that our
Unless there's
public member said that that should be opposed.
Is that a consensus, guys?
Yes.
Yes. I'm supportive.
The next bill is House Bill 2697, expired opioid antagonist. There is an amendment that's coming down for this. The initial language kind of stated that a pharmacist can fill it pursuant to a prescription, and a doctor can prescribe an expired opioid. So we're kind of taking that out and removing it from dispensing and prescribing and just giving out. The whole intent of the opioid is for nonprofit organizations to give out opioids. And I think the philosophy is that any form of opioid antagonist is better than nothing. But we did amend the language to remove it from definition of dispensing or prescribing and just giving out for no profit at all or no
And
fee.
I'm much more supportive of that than the original language.
Yeah. So consensus on supporting with the amendment?
Yes.
So are you saying like if it's expired, they can give it for emergency with no profits, with no charge?
Let me actually read it. I did draft the amendment, so I will tell you about it here.
Before it said it could be dispensed, which
Yeah,
I was
but then
concerned that there was an adulterated
not
product and all that stuff.
It can be given or.
So this is the proposed amendment. We did add without compensation, change the word pharmacist who dispenses an opioid or provides an expired.
This isn't in our book, is it?
This is not.
I can't read that.
The amendment has not been posted yet with the legislators, so I'll keep an eye out for that. And if and when the amendment posts, then we'll chime in support. If it doesn't post with the amendment, then I'm sort of opposed to it because it is, if a pharmacist dispenses it, then it could be deemed as adulteration because after the expiration date, you can't really prove purity and potency and all that stuff. The definition of adulteration is in federal law and it could fall under that category.
Yeah.
So the amendment was presented and I'll keep tabs on that. I'm hoping that you guys support the next bill because it's a continuation bill for the Board of Pharmacy, House Bill 2732. This is tied to the Auditor General report that I'm going to discuss. I could discuss it now and just get it out of the way. We did have our sunset review not too long ago. When was it? Last week, Frank? Last week. Mr. Thorwald was gracious enough to be there and voice his opinion on how awesome we are as a board. We were given 6 years as an expiration date, which is the maximum that they're giving nowadays, right? So, so kudos to Jennifer Gail Navong for keeping us on task, monitoring the Auditor General report, and the team as a whole. They did a phenomenal job. All the team leaders, all the team members, because it was all hands on deck when it came to providing the right response and an adequate response to each request that the auditors wanted. We are on our follow-up, 6-month follow-up already, and we've already got a slew of questions that they're asking. So, so all hands on deck again until that follow-up is complete, but it looks promising. So I'm just going to assume that you guys are in support of this bill.
Yes.
House Bill 2733 is the pharmacy board bill again, and renewals and ownership. This bill has three components to it, and I'll try to summarize it as best I can. The big component is change of ownership. We've been operating for years, decades maybe, on good faith, on allowing the existing permit to carry over to the new owners temporarily until we administratively review their application and then open it. And at that time, the new permit will take over. Permits are typically not transferable because they're allocated to the individual that we give it to. But we also don't want to hinder and stop business from operating. So we created this mechanism, change of ownership model behind the scene of good faith. There's nothing in statute, nothing in rule that allowed for that kind of practice. And that was just recently identified because we've been operating on this level for so long, we didn't really think about a statutory authority or not. So now we're just kind of codifying what our practice has been. There are some rules on publicly traded companies on how fast they can disclose their change of ownership. So what I presented in the bill to you guys originally is going to be modified a little bit to account for that. But rather than treat publicly traded companies and non-publicly traded differently, we're going to treat them all the same. And there should be an amendment coming down, which essentially says that at the change of ownership, you notified the board 7 days after the transaction is complete and apply within 30 days after the transaction is complete. So after the 30 days is up, then you're in violation of operating without a permit. Does that make sense?
That makes sense.
The other component of this is the CE requirements. Right now, I know we see a number of cases that upon renewal that they have to attest that they've completed the CEs. We're expanding that language to incorporate the entire 2-year window for technicians and pharmacists so that when they renew, it might be a reminder saying, I didn't do my CEs, but they still may have that couple of weeks left before their license expires for this cycle. So it might be an extra reminder for them. Makes it better for us as an agency also, because then we can just look at the 2-year window and see who's deficient rather than looking at each individual one and when they renewed and stuff like that. So opportunity for us, improves our operation, opportunity for them as a reminder. One final reminder before they don't do it, I guess.
So would that allow pharmacists or technician to renew their license in September, but they finish CE on October?
By the end of October.
By the end of October. Yeah, that's great.
Which I think honestly
have
would be
to
good for the staff too, because it incentivizes people to renew sooner, which would give staff more time to process it rather than them scrambling at the last minute. Because if they wait until October 30th to do their CE and staff gets 1,000 renewals, that's really not great for them.
Yeah. I think the other component is we consolidated prohibited acts. For instance, you need a permit for a wholesaler, you need a permit for a manufacturer. So rather than look through all our statutes and rules to see if you need a permit to do something, we kind of just took all that information and put it under prohibited acts. So you'll see that as well. So it's all in a nutshell on what you need a permit for.
Love it.
You guys all good with that?
Yeah.
Yes.
Next one is House Bill 2867. This is licenses, so in essence, driver's licenses, not proof of citizenship. Today, Arizona does check lawful presence in this country before they issue a license, which means my staff has to collect a driver's license when they have an application before them. Statutorily, Title 41, I think, dictates that they have to have lawful presence to have a license from our board. If this bill gets approved, then we're collecting an extra piece of information, a birth certificate or a passport or something to show lawful presence in the state. So it does create an extra layer of burden for us and for the applicant to provide that information.
So in your perspective, this would be a burden to the staff and could slow down licensure.
Could slow it down.
So do we accept other state licenses that may not do that sort of back?
We have a list of states that check for lawful presence, and we have a list of states that don't check for lawful presence. So when we have a state that doesn't, we do require an extra piece of information.
Dr. Gandhi, is that your suggestion as well?
Speaking of the operation for the board, that makes sense.
Sounds good.
Any concerns? Okay, go ahead.
House Bill 2953 pertains to civil penalty that the board can impose on entities that do not provide direct patient care. We've had multiple applicants before us that have done business in this state without a proper permit, and we fine them appropriately. This would kind of set a cap on what we can fine somebody. It would be $25,000 for a 6-month window, but we're allowed to look back 4 years. So in an event that someone violated that law, we could look back 4 years to see how much they distributed into the state and potentially charge them $25,000 for each 6-month increment.
So for those entity has no direct patient care like wholesalers or
Wholesaler shipping to a medical practice, for instance, or shipping to a pharmacy or whatever it may be.
Okay.
Yes.
That makes sense, I believe so.
And this also expands the ability to be more flexible in our non-disciplinary grid, as making those as caps so that there's negotiation allowed.
I have a different perspective on it. I think that if a company is going to put something in the state without getting a license to do so or permit to do it, they can put in as much as they want, and it's probably going to be cheaper than getting a permit and going through the process, because they know they've only got maximum of this kind of fine. And we've had other cases before us where they've put a lot more than that in. And I personally don't think this is a good idea because of that.
I think our board has taken a position to have a max fine of $125,000. So we've already set a cap for ourselves. This potentially could increase it to $200,000.
To me, I read it as reducing the cap from 120
For 6 months window. Now we can look back 4 years. So you take 6 months, 6 months, 6 months times 48 months.
Mm-hmm.
So if they do like a 7 month, you go 6 months and
Well, it's-
plus 25.
Yeah, you can look back 4 years total.
Okay, then that makes sense. Thank you.
I mean, I support, I mean, it makes it easier. Right.
I think we've been looking at being a little more flexible on our non-disciplinary grid as well. And I think it was a little rigid on $100 for items shipped, right? That was just unreal.
Millions.
And it didn't give us a avenue to negotiate in that space, so.
And it's a clean and it's, I believe, cleaner and easy. I support.
Any concerns with support?
Nope.
Okay.
House Bill 2965, Mr. Al-Nassif is recused from this discussion.
Do I need to move or just don't talk?
You can just close your ears, cover your eyes. Covered entities, 340B, drug distribution. It basically eliminates the manufacturer from restricting 340B distribution to where they feel like it's good for me to send it here, but not here kind of thing. So I don't want to use the word discriminate, but in essence, that's what it does. It lifts that barrier, and it levels the playing field for everybody to get to 340B who plays in that space without the manufacturer making a decision on who gets to have it and who doesn't get to have it.
this something that we would really want to take a position on? To me, it's like a business practice.
That is.
Like I have a personal opinion on it from a business standpoint, but I don't think it's for our board to decide.
So House Bill 2971, occupational license fee deferment. I don't know if I really have to summarize because it kind of explains itself in the title itself. So if anybody applies, they don't have to pay today, but they can pay in the future. And I don't know if, first of all, I don't know if our operation can handle that and then track and trace all these things all the time to keep tabs on it.
Oppose.
House Bill 4036, bulk drug substance prohibition. This is around GLP-1s and tightens Arizona's oversight on compounding weight loss drugs, particularly those using GLP-1s or similar active ingredients. This bill is tightening up compounding for GLP-1s in essence.
I was like, you know, I'm going to have an opinion here. As everyone knows, I work for the Alliance for Pharmacy Compounding. We do advocacy for in the compounding space. I think that any bill that singles out one singular class of medications that's otherwise federally allowed to be used in a compounded product is problematic. And some of the other components of the bill, like the requirement that the manufacturer be inspected in the last 2 years, where pharmacies don't have a control over FDA's inspection timelines and stuff like that, are really problematic.
When I read this bill, Madam Chair, if I can share my viewpoints and mine only, not speaking on behalf of the board, but this is a battle between manufacturers and compounding industry. I'm not sure if we as a board necessarily need to play in that space, because then we'll side with one or the other, and that's not a fight I want to get into.
I mean, there are bills in various different forms all over the country. This is a completely different version that I've seen in Arizona than I've seen anywhere else. But I tend to agree with you. I have two minds about what you said, Ms. Davis. You know, I don't like that it calls out one drug class, but I also think that there are certainly places where, you know, outsourcing is definitely necessary from a patient access standpoint. So I think can we stay out of it? Unless they need a fact witness, but I think let's stay out of it.
Similar bills are being introduced all over the place, and the only board that I've seen weigh in is one board in the South. All the other boards have either not been approached in the writing of the bill or have not taken a position.
Neutral it is. Next bill is House Bill 4047. And to your point, Mr. Anderson, when I drafted this agenda, these bills had not dropped yet. That's why I had the title, you know, as posted bills and potential bills, right? So House Bill 4047 is medical spas, licensure, and regulation. That was the most recent bill that was dropped that falls into our lap about the Board of Pharmacy regulating med spas. And it's limited to their drug inventory, like where they may purchase it from and how they store it and so forth. Not necessarily how the medical director practices and nurses practice in there. Now, if we see any nefarious activity, if this passed and we were to go in there and inspect, it would be our obligation to report it to the appropriate agency saying, hey, we witnessed these events. You may want to take a look at it. But from our perspective, it's mainly the supply chain around the drugs that are in there.
Is there additional funding for resources for?
So my ask is, I did get a call. When did I get a call? Yesterday. I found out yesterday who was sponsoring this, who was running this bill. And my ask was, if this was to pass, this is definitely needed. Med spas are a space that has no oversight today, including IV hydration, and that's a different subject matter. So it is definitely needed, but it doesn't call out how much we can charge for permits if it's under oversight. Um, it doesn't call out manpower that's needed for this. So there are some asks that I had. First of all, they put some sort of permit limit on there, how much we can charge. And then the board can determine how much. They can put a cap and we can determine what we want to charge. And then have a delayed implementation so that we can evaluate what manpower we need and who we need to look at these things. Just on initial search from Google is about 2,500 med spas in Arizona. It's quite a bit. I don't anticipate inspection to be as detailed as a pharmacy inspection, but it's still going to take time.
So this bill just for inspection, not for giving a permit or anything?
No, they would get a permit
They
from
would
us.
get a permit from us, yes.
Oh.
I mean, I'm kind of the opinion support if amended. I don't want to set up your team for failure, but I do think from a patient safety standpoint, something needs to be done. I don't know if this is the right way, but I 100% agree with your concerns about what this means for your team and for the capacity of the board.
There's so much research grade peptides and all sorts of things that are labeled not for human use being sold through these entities that I think that something needs to be done.
Yeah.
So Dr. Gandhi, does it also define what a med spa is versus how does it define a med spa versus?
It's an interesting definition.
Right.
Let me take a look, see if it's in there. Medical spa means any facility or practice that offers medical or cosmetic healthcare services and that is required to be licensed pursuant to this article. Does not include a facility or practice that is otherwise licensed by the state.
So how does that differentiate from a physician's office? Does it not?
They may be licensed as a clinic, not necessarily licensed. So
Yeah, that's a whole nother can of worms.
I think that goes back to Mr. Thorwald's discussion many years ago when you first started about harmonization of medication. How do you handle it, right? Handling and storing and all that good stuff of medications.
And I still have that concern even today.
Yeah.
More so, in fact.
So thoughts on that one, guys?
So support the intent, but there's work that needs to be done on the definition and resources for the board. Is that fair, everybody?
Yes.
Next one is House Bill 4102, Administrative Procedures Revisions. Makes comprehensive revision to Arizona Administrative Procedure Act to modernize, clarify, and standardize agency rulemaking and publication requirements. The bill expands and refines statutory definition, clearly distinguishes clerical or typographical errors for substantive changes, and tightens procedural timelines for rulemaking activities. It formalizes new notice types, such as rulemaking docket openings, standardizes template and filing requirements, and strengthens transparency through expanded electronic publication and public notice obligations. The bill enhances the role and visibility of agency ombudsmen. So that part doesn't pertain to us. There's another section that impacts ombudsmen. But it does kind of make it a little, it seems like it makes it a little more complicating for rule writing for the board. Am I reading that right, Ms. Galvin?
I would agree with that.
I think our administrative process is already challenging
Mhm.
comparatively to many states. And while I support the goal of trying to create uniformity, I don't know that I think we need it. And I don't think that adding burdens to the regulatory process is smart.
I concur with that.
So just to translate that, oppose. Okay.
Yeah.
Next, we'll move into Senate bills. Senate Bill 1124 requires Arizona health professional regulatory boards to give at least 14 days advance notice before voting to require a psychological, psychiatric, or physical evaluation of a health professional. The notice must summarize the complaint or action prompting the evaluation. The professional may submit a written response and has the right to appear and testify at a hearing. If an evaluation is ordered, the professional must receive a copy. If no disciplinary or non-disciplinary action results, the board must reimburse the evaluation cost.
Thoughts, guys?
I thought my voice is,
You have to start all over again.
okay. So my concerning about the reimbursement that we require to reimburse if for the evaluation. But to me, evaluation is not punishment, just we need to know exactly what's going on so we can make decision. So that's why I oppose. I mean, I'm not.
I support the opposition. Anyone?
I support it.
So I think I'll support it.
Agree.
I think I'm in the opposite court on that.
Yeah, I support the opposition. Yeah. So I oppose this bill. Yeah, this.
Why?
So Lori just jumped in and she corrected me already.
Turn your mic on.
Sorry. The reason I am on the opposite court on that, I think that boards can ask for too much. And sometimes that can be used to push people the wrong, punish people in ways that shouldn't be allowed. And as long as you have good people on the boards, that's not going to happen. But that doesn't always occur. And I think this is a way that codifies it in a way that supports that type of thinking and makes it less likely that you would ever do that as a board. I don't know that I expressed that exactly right, but that's basically my concern.
Madam Chair, can I play devil's advocate?
Yeah.
So we have someone that's borderline, we'll say sketchy, because that's a street term, right? I may be gun shy to issue an order for evaluation just for the fact that nothing could come back. And then now potentially we have somebody that may not belong in the practice. Just in the fear of, I might have to reimburse this individual, right? So how many of those am I going to reevaluate my thought process, having this in the back of my head saying, maybe I shouldn't give it?
I don't disagree with that. I think it's one of those controversial things, one way or the other. But I side on the other side of it. But I do see your thinking here, and I don't disagree with you.
Any change of heart with Mr. Thorwald's comments?
I support oppose.
Okay, go ahead, Kim.
Okay, next one is Senate Bill 1188. This is again bypassing the board and its rulemaking authority for scheduling a drug, and allowing prescribers to prescribe upon the changing of a scheduled drug at the federal level. So if it's moved from anywhere from Schedule 1 to any other category, then it becomes, it allows the prescribers to prescribe it. Right now, statutorily, we have the authority to adopt the CFR and align with the DEA's scheduling. So they're basically taking it out of our hands and putting, I'm not necessarily opposed to the language, but it'd be nice if we maintain that authority.
Do we think that this is because of the attempt at descheduling testosterone?
It's MDMA and it's other drugs. So, yeah. There's also discussion about, I think maybe firefighters or something with PTSD. There may be some treatment coming down the pipeline that is in Schedule 1 that could hit
Psilocybin.
something like that.
My perspective, I would be opposed to it.
Any other thoughts?
I see both sides, although we have the ability to change it in rules relatively quickly. I'm not sure that it's really needed, but I could go either way. Can we be neutral?
We can. But it may be still worthy of a discussion to change the language to say upon board making a decision at a public meeting, right? Saying we're adopting the latest version and then send a note to secretary. I don't know if that's allowed or not allowed statutorily. But we'll do it in public forum, send it to Secretary of State. I guess if the legislators put it in the bill and pass it, we would be given authority to just do it that way. But I don't know if they would. But that's worthy of a discussion. Senate Bill 1309, pharmacist care standard prescriptions. After talking to board chair, I did talk to AZPA about some minor revisions. Basically, I think the current existing language puts standard of care under unprofessional conduct under pharmacists and interns. Doesn't necessarily do it for technicians and technician registrants. And this board's been pretty good about breaking down where things fell apart in a situation and then holding the appropriate person accountable. If you don't have that standard of care in all parts of our license registration sections, then it falls on the burden of the pharmacist and intern. So one of the proposals was to put it in technician trainees as well. The other part of it is overall, I mean, it's black and white. A prescription, and when it's filled in an error, standard of care is you filled it wrong, and that's black and white. You compound something wrong, it's standard of care, you did it wrong. But there may be a situation where it involves battle of the experts, and that's one of my concerns, and that's what I presented to AZPA about maybe adding an amendment saying, because we're an appropriated board, legislators allow us so much money we can use, and we can't use our pharmacy general fund for really anything. So if we can leverage that in an event, we came across a case where it required battle of the experts, so we could appropriately fund an expert witness on our behalf, that would be ideal. So I haven't seen an amendment, so we'll have to see, and we'll keep tabs on that.
I'm very supportive of the concept. That's no surprise to anybody that's been around me for a while. But I do see your concerns. I think it might be worth reaching out to Idaho, see if they've had any similar situations, but I would like to support it if we can with the technical amendments. Any alternative thoughts? Anybody? Y'all are getting tired. We need to pick it up, Cam.
Almost done, another couple hours. Senate Bill 1458, already talked about this. This is just a mirror image of what we talked about in the House bill earlier.
Same position unless anybody thinks differently.
Senate Bill 1501, agency statutory authority, strengthens limits on state agency authority and expands protection for individuals with small businesses dealing with regulators. The bill clarifies that agencies may not impose fees, licensing conditions, requirements, or rules unless expressly authorized by state statute or law. It explicitly allows complaints and legislative review of statutes, rules, and agency practice that are duplicative, overly burdensome, or beyond an agency's statutory authority. Thoughts?
I have two opinions on this, and my one that is the greatest one is I think it gives legislators the ability to minutely manage what's going on, and I think that's bad because they won't have all the facts in them, and I think that would create a lot more work that the boards and that's unnecessary.
Okay, I'm gonna take Frank's word for it and oppose it. Just to speed up the process here. Any other thoughts, guys?
I support your comments, Frank.
I do as well. And I think, coming from the public member, I think that speaks strongly. We have a board of experts for a reason,
Okay, Senate Bill
including our
1542.
public member expert.
Senate Bill 1542 again takes the controlled substance approval out of our hands. And so this is the example I was talking about earlier with the MDMA, assisted therapy for post-traumatic stress disorder. So it's a good concept, but it'd be nice if they just had language that allowed us to expedite our rulemaking process in regards to this type of situation.
Makes sense to me.
Last one I have, Madam Chair, is Senate Bill 1814, Substance Use Disorder Treatment Committee. I think NABP was working on this as well to get a think tank together on how to manage substance use and standardize treatment and care across the country and get best practices so that everyone's not trying to create their own wheel. And it looks like this is what they're trying to do as well, overall, for this state and the different avenues. Departments, companies, whatever. Any thoughts on that?
Your suggestion to support it?
Yeah, I think that's where our position is. Anytime we have a healthcare professional before us, that's our first option, is to help them unless they've fallen off the wagon 10 times.
Yep.
Is to help them get better and keep our fingers crossed that they come out, in a good space at the end of the day. So.
I'm good with that.
I've already talked about the sunset review, Madam Chair, and with that ends my report unless you have any other questions or comments.
Board members, anything else on Dr. Gandhi's report that you want to talk about? All right, let's do call to the public.
Yeah. Madam Chair, I'm taking tomorrow off. I've never talked so much in my life. But just for the record, actually, I'm not going to be here tomorrow. I am in transit for another meeting. But I think we covered an enormous amount of agenda items today, so.
I agree. We will be in Jen's capable
We'll
hands.
be in great hands, better hands than mine.
Are we good, Cam? We will recess for the day. See everybody tomorrow.